The following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori, good evening, everybody. Welcome to the following program. I'm your host, Joe Neerman, aka Good Logic. I'm hearing myself echo. Oh, I know why that is. That's because I've got my second YouTube channel, Trump Trial channel, playing in the background. But I just shut the volume there. So, where to begin? Okay, a few places to begin. First and foremost, I don't have anyone to read with me. This is not good. See, I figured, foolishly perhaps, but I did figure that if I threw out a call out there into the ether saying, hey, anyone who's like halfway decent at doing a Trump invitation, love to have you on the show tonight. I'm going to throw it to you guys. Seriously, you could be some of my audience. If you think you have like a killer or at least decent, I'm going to go with decent. Doesn't have to be a killer. Decent Trump imitation. Better than mine. Mine's not very good. It's not very good. It's terrible. I don't ever dust it off because it's terrible. It's terrible. If you sound any more like Trump than that, which is not a high bar, it's a very, very low bar. It's a bar, the bar's all the way down here. In fact, it's actually probably much lower than that. It's probably like way below my chair, the bar. That's where the bar is. Very low bar. Very, very, very low bar. If you can surpass that bar, I will be happy to kick out anybody to you. Seriously. Seriously. No, really. I'm not kidding. I'm not kidding. It's a very low bar. The other thing I wanted to mention is I am streaming right now to Rumble and to YouTube on Good Logic, and I'm streaming over to Trump Trial, my debut video on Trump Trial. Not going to kid you. I'm not hiding the ball here or misleading anyone. I really need to rack up 4,000 hours, viewed hours, in order to be eligible for monetization on that channel. At a certain point here, I'm probably after midnight. I expect to run long tonight. Probably going to run long. And at a certain point, I'm probably going to take my Good Logic channel and cut that, and I'll continue streaming on both Rumble and on the Trump Trial channel, just to encourage those of you who are on YouTube to swing on over there. I will give you a heads up beforehand. It's not gonna be like all of a sudden everything's gonna drop dead on you. That's not gonna happen. So that's where we're at. When I saw, how did I come to this transcript? You might be wondering, Joe, where'd you come up with this transcript that you're gonna be reading to us and going through with us? Well, I was looking through the motion that Trump brought for mistrial, and what I realized is I'm admitted in New York. I can just go through any public file and pull up their records. And when I pulled up the records, one of the exhibits that was attached to the motion was the transcript for the whole freaking trial. And I'm like, oh my God. I have the transcript from Trump's day in court, along with the rest of the stuff that had happened as of the date when they filed the mistrial motion. So started parsing through that, and I was like, oh yeah, this is something the world needs to hear. They need to, because everyone was like reporting on it. I was reporting on it, Inner City Press, Adam Klasfeld, all of us were trying to capture what was happening in court that day. But now you can actually see the words. It's not the same thing as being there. Trust me, it's really not, because you don't get tone and context and all that other stuff. But this is the best rendition that 98% of you are ever gonna see. So I felt like that's something that I'm offering the world, which few people have been offering. Maybe a couple have, but few have been offering. Drop Barrack Cruz says Trump impressions. I highly recommend Trump speed dating Gillian Keeves sometime. It doesn't have to be very good. It doesn't have to be very good. It doesn't. It just higher than that very low bar that I have. That very low bar that I set. Very low. Whew. All right. So Oh, and also I missed this. Chugi Show says, why not do this on Trump's trial channel? It is. Good way to get monetized in time for the actual trials. It is there. It is there. In fact, I actually have in there right now 59 people watching there. And when I shut this thing down here, when I shut it down on, I expect that it's probably going to shoot into the several hundred people watching at once. So should have asked Nick. He does a Trump voice. I thought about asking him. It was because, you know, I haven't had him on here a long time. And I've appeared on his channel a couple times since then. I very strongly considered, I was like, it's short notice. I don't want to just throw that at him. Strange, I'm sure I had to resub like 2 days ago, or was it last week? Yeah, that's the way it is. That's the way it is. I appreciate your support, though. I do appreciate your support. Let's get into this thing. I'm also, after I'm done going through this, which is 170 pages, so I sort of going to read like a little quick, okay? It's 170 pages. At the end of it is where you have that whole incident where they're screaming at each other about, and they're saying, we need to follow this motion, and the whole back and forth. So you'll actually see word for word, although I did notice one infamous quote that is not in this transcript and should be there. It should be there, and it's not. But we'll come to that. We will come to that. No, I need a reader. I need a reader. That's what I need a reader, because I'm really going to start reading a transcript right now. All right, here we go. This was on November 2nd. November 2nd, November 4th. What day was this? This was on. Let me pull it up for you. Present. Share screen. Entire screen. Where I am. Share. Okay, we'll make this a little bigger. It says November 15th on top. That's not the date. That's the date that the motion was filed. The date that this transcript happened was November 6th. So it was 2 weeks ago today. I thought it was 2 weeks ago today. November 6th. All right. First it was blah, 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 blah. I don't care about that. Court said, I want to start right away with the next witness. Are there any housekeeping matters? Not that can't wait, Judge. Minor housekeeping matter, but if Your Honor would like to proceed, we'll just wait until later. Great, thanks. Plaintiff, would you like to? That's more appropriate voice for Engoran. Plaintiff, would you like to call your next witness? Certainly, Your Honor. The people call Donald J. Trump. And that's how it all started. Oh my God. What is that? Audie Joe saying, I'm celebrating. I've been fostering my niece. Today she got back. She got to go back home. It wasn't easy. Well, God bless you. I'm gonna give you another one of these. God bless you. I have great respect for people who adopt, take in foster kids and things of that nature. I mean, that's such a level of self-sacrifice to try and better the life of another human. Mad props for you. Really, really, really. I mean, that's not an easy thing to undertake. And getting her to go back home, I wish nothing but blessing for her. I mean, I understand that she's a relative, she's a niece, but I'm glad that situation is more stabilized now. Great job. Great. I'm giving you one more. Don't stop me. Check your DMs, you boomer. Check my DMs. When was I supposed to check my DMs? Yeah, I'll send you an invite. I'll send you an invite, Joe. Joey, I'll bring you in. I'll bring you in. You can be my huckleberry. It's probably easier. It's probably better if I have two people here anyway. I think my Engoran's not bad. I sent you that invite. All right. So I'm gonna bring Joe in here because I think with two people here, it's gonna be better. It's gonna be better. It has to be better, right? And I trust Joe. Joe's good. Joe is good. All right. Meanwhile, the court says, great, thanks. Plaintiff, would you like to call your next witness? It's really kind of how he talks. Certainly, Your Honor, the people called Donald J. Trump. Whereupon the witness took the stand. Court officer, please raise your right hand. Donald J. Trump. After Donald J. Trump, after having first been duly sworn, was examined, testified as follows. Here we go. Please state your name and either home or business address for the record. That's what they always do. Pick your name. Give us your name. Pick your business address or your home address. Yes, it's Donald J. Trump, and I live in Palm Beach, Florida, 1200 Southern Boulevard. That sounds good. Okay. That sounds good. Hey, Ralphie boy. That sounds good. I'll just ask, like I ask every witness, talk right into the microphone loudly, slowly, clearly. Mr. Wallace, please proceed. Now, that is something I'm sure he says to everyone. I'm sure he relished saying it to Trump, but he knew that people are going to like try and pick on it. So like that's why he decided to say, hey, this is what I tell everybody. So don't think I'm picking on you. This is just what I say. It's what I say. Did you got my DM? Okay. You're there. Morning, Mr. Trump. Good morning. Good morning. You were the beneficial owner of a bunch of companies branded as the Trump Organization. Is that correct? Yes. From May 1st, 1981 to January 19, 2017, you were the director, president, and chairman of the Trump Organization Incorporated. Is that correct? Yes. And the assets of the Trump Organization are currently held in a revocable trust. Is that correct? Yes. And that trust is called the Donald J. Trump Revocable Trust. Is that right? Yes, that's right. If we talk about the trust today, you will understand that's what I'm referring to. Now, this is a common thing that lawyers do. They sort of want to have something defined and go on the record saying, this is what we're going to call it. So, I'm not going to repeat the whole name every time because it's just too much of a mouthful and makes things more confusing. But when I say the trust, that's what I mean. Yes, certainly. You are the donor of all of the assets in the trust. Yes. Are you the sole beneficiary of the trust? Yes. And you formed the trust when you decided to run for president. Is that correct? Pretty much when I won, I formed the trust. Do you recall that the trust may have been formed actually in 2014? It could have been earlier, but it was primarily when I thought about running, and I think maybe came into, it could be a little earlier, but pretty much around that time, around the time that I won. And the purpose was related to your run for the presidency. Is that correct? I thought there would be a conflict of interest if I had the properties outright, so I formed the trust. But no, excuse me, even though I would be allowed to do that. In fact, I told you the story once about George Washington. He had two desks, one for business and one for president. You're allowed to do that, but I didn't like it. And I thought there may be a conflict of interest, so I formed the trust. You. Let's do it this way. Well, is that going to work? No, it's not going to work. Let's do it this way. This is Joey Boy. We'll do it this way. No, that's too small. That's way too small. We're going to do it this way.
It's got to be very large.
That's not bad.
Bigly. Look, everyone. If you ask around, you'll find that everyone seems to agree. It's bigly. It's obvious. It's bigly. It's been bigly ever since I've been. It's been
that, and no doubt indeed.
I do need to set something up before just 1 second. Technical moment.
Yeah, do what you got to do.
Yeah, all right, we're ready.
All right. Should we do it? Should we do it like this? Should we do it like this? You can be able to see.
Oh Jesus, I'm in trouble.
You can be able to see?
I can see. I mean, Jesus Christ. I'm doing this for fun, for the fans, because I'm a fan, and
he's like one of my first fans I ever had here.
I'm cult follower number 6.
There you go. Who is number?
You're the one who's got the records in the great vault on high.
But you really could be like cult follower number 6. It's been here like since the days of 30 people in here.
Yeah, it was fun stuff back, when
I was desperately trying to reach my minimums for monetization. And he was one of the folks who were helping me out. All right, let's get into this because we got a long way to go here. We got like another 150 pages.
So is A for Trump here? Is he? I'm sorry, I just jumping in. He's answering.
He's answering. Yeah. All right. You ready? Let's do this.
We'll find out.
But prior to you becoming president of the United States, you were the sole trustee of the trust. Is that correct?
That's correct. Yes.
And after you were elected president of the United States, you appointed your son, Donald Trump Jr., and Alan Weisselberg as trustees. Is that correct?
That's correct. Yes.
We can do a little faster, okay? I know you're doing your best, Trump, and I definitely appreciate. But
please continue.
Okay. So why did you select Mr. Weisselberg to be a trustee?
Well, he had been with the company a long time, and he was somebody that I had confidence in. He did a good job. I mean, he was very good at what he did. He was a comptroller and a financial person, and we really liked him a long time.
And you trusted Mr.
I did, yes.
At the time you appointed him as trustee, he was the chief financial officer of the Trump organization.
Yes, that's right.
Why did you select your son Don to serve as a trustee?
He's a hardworking boy. You know, a young man, and he has done a very, very good job. As Eric is a very busy man, running the company, and I thought that putting Don in would be good. He is smart. He's an honorable guy.
I'm trying to figure out how to close out my tab. Do you know how to close out this thing so I don't show the thumbnails?
Oh, geez, Bruce. Now I'm going to do Trump and tech support.
Yeah, basically.
I'm going to have to. You're going to start sending me super chats. I don't know, bro.
He's saying remove the side thumbnails and push with full. Like that's like, oh, obviously. Hello.
Well, it's on the obvious. There's an NE key here somewhere. There it is.
I don't know what that means. Fit to page. No, God, that's better. All right, whatever. And when you left the White House, you appointed yourself as trustee again. Is that correct?
That's correct.
And at that time, after you left the presidency, you were the sole trustee of the trust. Is that correct?
Yeah, around that time, yes.
Why did you make yourself the sole trustee?
Well, I figured that I would scroll the fucking page in front of my friend. You're killing me, Smalls. Well, I figured that I would be back in the business world for a little while, depending on what happened in politics. And I was going to get involved in the business again. It wasn't in politics. Other than that, thinking around running or doing whatever I had to do. So I figured that I would be back in business. I might as well be the trustee.
I'm going to hand up to the court officer a document that's been marked as Plaintiff's Exhibit 1720. If you could put a copy of that up on the screen, please. If we could skip to page 2 of this document. This is a document entitled The Donald J. Trump Revocable Trust Removal of Trustee. And if we look down at the bottom of the page, it says, now therefore, pursuant to sub-article A of Article 13 of the Agreement of Trust Settlor, hereby removes Donald J. Trump as trustee under the Agreement of Trust effective as of 2:30 p.m. Eastern Standard Time, July 7, 2021. If we look on the next page, you'll see, is that your signature?
Yes.
Why did you remove yourself as trustee as of July 7, 2021?
I don't know that. I think we were in a position where I was gaining more confidence in my family in terms of the business. And let's try this again in English, right? And you would have to see that what the alternative is. Who were the trustees? Who's appointed? Because I had many different. Really? What are the trustees that are appointed? Because I had many different. That can't be the freaking transcript, dude.
That sounds like Trump, actually.
Jesus Christ.
Who were the trustees who were appointed? Because I had many different.
No.
Sure.
Grammar.
Sure. Yeah. I'm happy to show you page 5 of this document, which is entitled Appointment and Acceptance of Trustee. It states at the bottom, now therefore, pursuant to subarticle A of Article 13, the argument of agreement of trust, settler hereby appoints Donald J. Trump Jr. as trustee under the agreement of trust. And Donald J. Trump Jr. hereby accepts such appointment effective as of 2:30 p.m. Eastern Standard Time, July 7, 2021.
Yeah,
So that's your son, Don Jr.?
that's right. He was impressive in business. He was,
Has-
as was Eric. And I thought that I would do that while I continue onward with politics.
Okay, anything in particular was happening in July of 2021 that led to that decision?
Well, other than you and about every other Democrat district attorney, AG, and U.S. attorneys, etc., were coming after me from 15 different sides, all Democrats, all Trump haters, and all cases that are not good, that are inappropriate and not good. Weaponization, they call it. But I felt Donald would do a good job. He would be running the business with Eric, and I had a great confidence in him.
It's such a Trump answer, isn't it?
It is. It's like
I told you guys, he was like the Trumpiest Trump imaginable on the stand. This transcript is bearing that out.
No, just to be clear, I was not the Trumpiest Trump.
No, not
Donald.
you. No,
I'm just
you're
having
just
fun with my
marginally
friend
better
Joe.
than me. You're just
Marginally
marginally better than me. Yeah,
more Heineken.
and braver. So I'm just trying to understand, was the decision to appoint Don actually related to the investigations you referred to?
I think more so to the fact that I was staying very much in politics. You know, obviously, as you see it, I have been in politics pretty much more than I thought, perhaps.
Okay,
wow,
Mr. Trump.
What the hell? 170 pages of this?
Feel your Trump. Feel your Trump, and
Oh,
it will
Jesus.
sound logical to you. It will sound logical to you. Just feel the Trump. You can't just talk like Trump. You have to be Trump.
Yeesh.
Okay,
my
Mr. Trump.
parents are from the Bronx, not from Queens.
Okay, Mr. Trump, I'm going to put a document up on the screen. I don't think we need to have a hard copy of it. This is a document that's awaiting evidence as Plaintiff's Exhibit 787. This is a copy of your 2011 Statement of Financial Condition. Is that correct?
Yes.
Is it correct that you had a Statement of Financial Condition prepared as of June 30th for every year from 2011 until you became president in 2017?
I think so. Yes, Mr. Wallace, Your Honor.
No, that's me. That's me.
Oh, that's you?
Yeah, that's
All
the
right,
questioner is Mr. Wallace, but now I'm not asking a question to you. I'm talking to the court.
Okay.
Yeah, on a housekeeping, I failed to move into evidence documents 1720, which was the trust document we just looked at. Granted, it's in evidence. Thank you, Your Honor. If we could go back to the Statement of Financial Condition, is it correct that you had reviewed the Statement of Financial Condition in each of those years from 2011 to 2017 before it became final?
Yeah, I will look at them. It was not something that was of great urgency because I knew they weren't very badly needed, and it was the true sense, but I would look at them. I would see them, and maybe on occasion have some suggestions.
When you say they weren't badly needed, what do you mean?
Banks didn't find them very relevant, and they had a clause in it, a disclaimer clause. You call it a worthiness statement clause because
worthless statement.
A worthless statement clause because they were done in such a way that they really were. You talked about it here recently, a compilation. There was something that you would have
just something that you would have for yourself.
Yeah, there you go. But if you were borrowing money, and as I guess people are starting to say, I was very leveraged.
Probably was leveraged.
A way to start off with.
Anyway, we didn't even start with it.
Oh, yeah. But there were not really documents that banks paid much attention to. They looked at the deal. They looked at the asset. If it is real estate, they looked. Scroll. This is crazy, dude, when somebody else is scrolling.
Yeah.
It's all good.
They looked at the location.
They looked at. These are not very important. Preliminary for the reasons that you had a disclaimer clause that was very, very powerful.
And that's really key to him, is that he keeps saying there's a disclaimer clause which says don't rely on these documents. So how may be held that I committed fraud and tricked them with these documents when there's a word? It's not really a disclaimer clause. It's actually called a worthless statement clause, which basically says everything in here is essentially worthless. So and should not be relied on. Audie Joe, break his fingers, huh? Forget about it, Joey.
Forget about it.
Forget about it. Where was I? Yeah. So, how did you know that the banks did not pay much attention to your statements?
Because, okay, I'm sorry, my screen just blocked it a little bit. Because I've been dealing with the banks for 50 years, and I probably know as well as anybody. And I have borrowed a lot of money. I have paid back a lot of money, and I know what they look at. They look at the deal. They look at the location. They don't want to get involved in the financial statements because that's not what they're after. If a deal goes bad, they want to be able to take that deal back over and, have it. They want you to be able to put up some cash or whatever it is you may be, including expertise, but they do not want to be fighting for 10 years over personal financial statement. They want to take over the deal.
So you understood that these statements would go to the banks, but it is your view, based on your experience, that they didn't rely on them very much?
They may have to go to the banks. Some wanted them. They didn't. They just wanted a very important element in the bank's decision-making process. And we'll explain.
We'll explain that as the trial.
Yeah, as this trial goes along, this crazy trial goes along, because we are bringing some of the best, some bankers. I'm freaking putting Trump in it. This is nuts. And the bankers will tell you, very big bankers, I want to say the best bankers, bankers that dealt with me, and they will explain exactly what their processes were. But these were very substantial bankers, and they'll explain what the process is. But they paid very little attention to the documents, unless they were certified documents, unless they were at the highest level. Everything was checked. Everything was, but even then, they were even more interested in the deal.
Mr. Trump, Mr. Wallace is being very patient, but I would like to move things along a little faster. Please, just answer the questions, no speeches. Mr. Wallace is going to ask questions. You're going to answer them. I'm going to make sure that happens. And some of your answers have not been responsive to the question. They responded, but then there's a speech to be had after that. Mr. Kais? So Mr. Kais is Trump's attorney. So he's like, Your Honor, respectfully, I've been watching that. All of Mr. Wallace's questions have called for narratives, not badly needed. What do you mean? That's an open-ended question. How did you know the banks didn't rely? That's an open-ended question. Which is true. He could have asked some closed questions saying, you don't know for sure that they didn't rely on them, yes or no. But he didn't do that. He said, what made you think that? So he goes on a long thing. So you understood. I mean, if Mr. Wallace is going to ask open-ended questions that call for narratives that I haven't objected to, ordinarily, I like to object to Mr. Wallace's questions, but they're narratives. So if they call for narratives, I think it's fair for the witness to narrate. He'll certainly understand your instruction, but they're open-ended questions he's asking. He's not asking narrow questions like, what do you mean by, this? What is your understanding of that? Those are questions that call for narratives, respectfully. Well, we agreed on the principles. We disagree on the applications. Let's just continue. Thank you, Anna. Why don't we go through one of the later statements in a little more detail? If we can get Plaintiff's Exhibit 730, please. This is an evidence, Your Honor, so providing an extra copy for the witness. Which, by the way, that whole back and forth there, that's a very common type of thing when you have a judge who hates the guy. He's like, because normally it's not the judge's role to start playing in there as to how they're answering. It should be on the prosecutor or the plaintiffs or the person who's asking the questions of a hostile witness to say, Your Honor, I didn't ask for him to read me the Declaration of Independence. I asked him a simple question. He's not answering. But the judge here is doing this on his own because the judge is interested in doing this on his own. Mr. Trump, I have handed you a copy of a document that is in evidence as Plaintiff's Exhibit 730. Do you recognize this as a copy of your 2014 Statement of Financial Condition?
Yes, I do.
If we can turn to page 2 of the document, we'll put it up on the screen. Second paragraph states Donald J. Trump is responsible for the preparation and fair presentation of the financial statement in accordance with accounting principles generally accepted in the United States of America, and for designing, implementing, and maintaining internal control relevant to the preparation and fair presentation of the financial statement. Is that statement true and accurate?
True in the sense that what they wanted was this was Mazar. Is it Mazars or Mazars?
Mazers.
Mazars?
I
Okay.
think so.
This is Mazars. What they wanted was much information as we could give them so that they could do their statements. And if you look at every other paragraph, that's what they talk about.
I'm not mouthing like I'm rooting for him to read it right.
Well, I'm rooting for me to read it right too. God damn it. I'm just trying to have fun with my friend Joe in front of about 500 of our friendly strangers. And I'm follower number 6.
That was really funny. Was the So is it true that you were responsible for the preparation and fair presentation of financial statements?
Getting them information, yes, in a form of getting them information.
Okay.
What the Jesus, bro? Really?
See, what happens is sometimes you don't realize, because when you're reading a transcript, I wasn't there for this part of it, but it's very likely that what happened was he goes, getting them information, yes. In a form of getting them information. Like it's like sort of like there's like a long pause there, and it's like nothing's happening. So he just is still rambling, you know what I'm saying? And it's repetitive. That's a common thing that you'll see in transcripts if you read enough of them. And you understand that the person feels like he's in a conversation and not preparing something to be read on a transcript. You know what I'm saying? But the court reporter is just taking down every word. So that's what
happens. Yeah. That makes sense.
I learned this lesson when I was I was being taught how to handle depositions. First job I ever had, I was doing a deposition 3 days after I got admitted to practice law. And one of the things that James Gear, the attorney who taught me this, said was, always remember that a transcript is just a bunch of words on a paper, and there's no tone. Context gets lost, everything gets lost. So I remember he's telling me, he's like, I remember I was in this worst pissing match with another attorney, and we're jawing at each other back and forth, and all of a sudden she goes, so when she was asking these ridiculous questions, and I said, this whole thing would have ended the whole thing would have ended an hour ago if you weren't a completely incompetent attorney. And she goes, excuse me? He goes, and right away in my brain, it clicked to me that just reads on a transcript as, excuse me. So I said, that's okay. I accept your apology. And that's how it reads on the transcript, even though like she was like not saying excuse me. So if your brain is playing along as you're hearing words, you understand how something will read in a transcript. But if you're just a witness on the stand, that's not how you're thinking. You're just rambling, and court reporter is getting it down. So he said, getting the information, yes, informs getting them information. Okay.
Yeah.
Go on.
I'm sorry.
Yeah. And if they have
they had a problem with it, they would have done the statement.
They wouldn't have done the statement.
They wouldn't have done the statement. In other words, if they didn't get what they wanted in that paragraph, they would call. Can you get this? Can you get that? And they wouldn't do the statement.
So who's responsible? Well, we'll strike that. Can you tell me, what did you do to meet your responsibility for the preparation and fair presentation of this financial statement in accordance with accounting principles generally accepted in the United States?
Me personally, or?
Let's start with you personally.
Okay. Well, first of all, it is so long ago. This is well beyond the statute of limitations. I think anybody else would be well beyond the statute of limitations, but I am probably not, because I'm sure the judge will rule against me, because he always rules against me. But this is something well beyond the statute of limitations. But I will tell you, my primary thing was to tell people to give them anything they needed.
Mr. Kais, was that comment necessary and part of the narrative to answer the question? Well, Your Honor, he is asking broad questions about him personally. I think what he's trying to understand is the witness's perspective. I mean, this is an unusual situation in an unusual trial. I think the court should grant the former president of the United States and according to the New York Times this morning, perhaps soon to be the future president of the United States, a little latitude to explain himself. It is a bench trial. There is no jury. If it's his view, it's his view. Your Honor is in charge of the courtroom. You have our view. You can instruct him as you see fit. But again, Mr. Wallace is trying to get at what is this witness's understanding and what he did. Now, by the way, just to pause here, the reason he mentions a bench trial is this is something that he's throwing back in the judge's face, something the judge has said repeatedly, which the judge has said repeatedly. A lot of times when evidence is supposed to come in or they're objecting to it, it's like, there's no reason for this evidence to come in here. It's prejudicial. It's harmful. He's like, nah, this is a bench trial. There's no jury here to be tainted. I understand the magnitude of weight to afford it, so I'm going to allow it. So now he's sort of throwing that. So Kais is correctly and wisely throwing this back in the court's face, saying, you're worried that he's going off in the mouth and that's going to just harm things here? How's it going to harm anything? It's a bench trial. You can know what to tune out, what not to tune out. So why are you worrying about it? It's a brilliant comment that really is far more powerful if you've had the benefit of sitting in a courtroom, which unfortunately Judge Engoran doesn't want to allow anyone to do. You can instruct him as you see fit, but again, Mr. Wallace is trying to get at what is this witness's understanding of what he did. The only way he can present that is to explain his position. I think it's fair for the court to hear his position, whatever it may be, whether it agrees or not. I certainly think it is fair for the American people to hear his position, but we're subject to your Honor's instruction. That's a way of finally at the end, like, obviously it's all yours. I just happen to think you're a D-bag. but I'm not saying those words, but he basically explaining in polite language why it is that everything you're saying here makes no sense. I think it was a yes or no question. Was he responsible? Is the question to me, or the comment that I always rule against him, which, as you know, is not true anyway. It certainly didn't answer the question. So, Mr. Trump, just answer the question. You can attack me. You can do whatever you want, but answer the questions. Could we get a read back, please, Your Honor? Read back, please. Whereupon they read the court back. The question is, yes, what did you personally do to fulfill your responsibilities for the preparation and fair presentation of the financial statements?
All I did was authorize and tell people to give whatever is necessary for the accountants to do the statement. In other words, we supplied them with what they needed. And if they didn't get it, they wouldn't do the statement.
What people did you authorize?
Really, anybody, sometimes they would call a building or they would call a project, or maybe perhaps I think one or two times maybe they wanted to go see a project. They would go out to Westchester and see something that I did out there in Briarcliff Manor, or do things I authorized. Whatever they needed to get the statement done, they could do.
When you say that they would go to see a project, are you talking about the firm Major?
Excuse me.
You said that sometimes they would want to go see a project. You mentioned Westchester. Is the they that you're referring to Mazars?
Yes.
Who internally at the Trump organization would you provide the direction to give Mazars whatever they wanted?
Almost anybody. If somebody would ask, for instance, if they would call somebody within the organization in purchasing or whatever, I would give them. But I would do it principally. I'm sorry. It's the grammar is killing me. Right? Because I would do it with, but I would do it principally with Alan Weissenberg or Jeff McConaughey.
I think there should be a period. McConaughey.
Yeah.
I think this was a period after it.
Yeah, all hail the court reporters. God, this has got to be awful work.
Yeah. Any other instructions besides, let me withdraw that question. Would you provide Mr. Weisselberg and Mr. McConaughey with any instructions for how the statements should be prepared?
Not really. No, I just prepared them to I just wanted them to get the information to the accountants so they could do the statement.
If we could turn to page 6 of this document, this is the top. It states, basis of presentation, and says, quote, the accompanying statement of financial condition consists of the assets and liabilities of Donald J. Trump. Assets are stated at their estimated current values and liabilities at their estimated current amounts using various valuation methods. Such valuation methods include, but are not limited to, the use of appraisals, capitalization, or anticipated earnings, recent sales and offers, and estimates of current values as determined by Mr. Trump in conjunction with his associates and, in some instances, outside professionals. Let me ask first, Mr. Trump, Is it correct that you were responsible for determining the value stated in this financial statement?
If somebody would ask me an opinion, I would give it to them. If Mazers would ask me an opinion, which they rarely did, I mean, if you were talking about many years ago, you were talking about over years, but I would certainly, I think I'm probably more an expert than anyone else. I think I, have shown that I know more than about real estate than other people. If somebody would ask me or if I would have an opinion, I would give it.
In light of your expertise in real estate, do you recall ever thinking that the values were off on your statements of financial condition?
Yeah, on occasion,
What were some of those occasions?
both high and low, both high and low.
What occasions do you recall?
Sorry, I had a cough there.
No, that's all right.
Anyway, where am I? Leave the gun.
Dear Coach Joe, you're not MGM. It's the Don's English. It is the Don.
Yeah,
it's not the Queen's English. It's the Don's English.
I read a thing about a Christopher Walken is also from Queens.
Christopher Walken
with that rhythm of, and he attributed his rhythm of speech to the excuse the term, the multicultural nature of Queens.
Yeah, there's nobody,
all kinds of broken English.
People in Queens do not talk like Christopher Walken.
Right, but people in Queens don't talk like anybody from anywhere else, so it sort of makes sense.
Is that really true?
Are you
hating on my? Are you hating on my native homeland?
No. Well, hey, first of all, my mother's born in Queens,
right.
And my wife's Filipina, and there's a big Filipino community in Queens, so I got nothing but love for Queens.
There you go.
There it is.
All right. So
and that's where.
Yeah, I'm sorry. Yeah.
I thought Mar-a-Lago was
he's being asked which times, and those of you who joined late, at this point, Trump is about to answer a question as to which times he thought the valuations that he had presented to a bank were, he later thought they were incorrect.
I thought that Mar-a-Lago, right. Let's try that in English. I thought that Mar-a-Lago was very underestimated, but I didn't do anything about it. I just let it be. It didn't matter. I didn't care because numbers you were talking about here, they're very big numbers, very, very big, far bigger. The values are far bigger than what is on the financial statement. I thought Mar-a-Lago was underestimated. I thought 40 Wall Street was very underestimated because the building has tremendous value. I thought that there were numerous other things. I thought Doral was very underestimated. I thought it was considerably more valuable, not necessarily as golf courses, but it is right in the middle of Miami, right next to the airport. I would say that you could build thousands of units and hotels on the site. So you don't look at it as a golf course. It's a great golf course. Very successful.
Very successful.
4 of them. 1 was sold. It was 5. 1 was sold. That was a little disconnected, and I sold it. And then Trump continues. But I thought Doral was very underestimated. And you yourself had Mar-a-Lago. No, that's not me. That's that. And you yourself had Mar-a-Lago at 28 million. That's not me. That's got to be the other attorney, right?
No, it's still him.
Oh, the judge had it at 18 million. And it's worth, I say, from 50 to 100 times more than that. So I don't know how you got those numbers, but the judge ruled against me based on the fact, I guess, that he thought that it was worth 18 million, which is absolutely crazy.
The question was examples of when properties were undervalued or overvalued, not why you think so. Oh, stop it. That's so stupidly ticky-tacky. He wouldn't do that to anyone else. It's ridiculous. I may ask about those as you go on, which, by the way, I just want to point out one other thing. A reason that that's inappropriate for a judge to be interjecting here and cutting him off is because sometimes the questioner may want him to ramble at the mouth. It could be beneficial to the questioner for the witness to just ramble on and on and on and on. It is grossly inappropriate for the judge to start chastising the witness as to talking too much without a request coming from the party who called him up to the stand saying, Judge, he's not answering my question, can we, and asking the court to step in. But in theory here, the judge could be stepping all over the AG who wants Trump to ramble on and open up more opportunities for other things for him to question him about. So it is so inappropriate and would not happen but for the fact that it's Donald Trump on the stand here. I may ask about those as you go on. Your counsel are free to either cross-examine you or call you as a witness, and you can tell the full story as you see fit, but it will go faster if...
That's fine.
You mentioned Mar-a-Lago, 40 Wall, and Doral.
Oh, and others. But I think that I can think of, I'm sorry, one that was, I thought, overvalued, and we can change it.
And we changed it.
Yeah, that's right. I thought Joe would scroll. The apartment was overvalued when I looked at it, but I didn't spend a lot of time looking at this. But when I heard about the apartment and the valuation, I thought it was overvalued. But you never know, because people come along and they will give you an apartment was sold fairly recently in New York for $250 million. I like this much better. So I don't know what overvalued means. Someone comes along, it only takes one very rich person to buy it. But I thought the apartment was high, but I thought many things were low. And we didn't value the most valuable asset. And I didn't put it on the statement, but it is the most valuable asset. Wait a second, but it is the most valuable asset is the brand value. Okay, again, this is Trump speak.
Mm-hmm.
See, I didn't have this transcript like ever. I'm totally cold reading this.
We're both cold reading.
Yeah, but you're like a professional reader.
Oh, fair enough.
Anyways, I'm just having fun with my friend Joe.
Mm-hmm.
And I asked about that, and I really didn't. I didn't put it on the statement. But if you look at the companies, the brand value is a very big part of the asset value of the company.
This trial is about the fact that they say he committed fraud by filling out valuations for properties that they say were grossly inaccurate and designed to trick the bank. The bank is not complaining. The bank is happy. He paid off the loan, or certainly they essentially paid off the loan, and nobody cares about it. And he says that this is ridiculous. It's bizarre for the AG to be looking into this, and there's no way on earth that they would, if not for the fact that it was Donald Trump who they felt they can go after here. And he also says that there's a disclaimer, what he calls a disclaimer, which is actually a worthless statement, which precedes these financials and says, hey, these are all my valuations and they're kind of just off the top of my head and some of them are purely guesswork. You really shouldn't rely on these. And the judge, when they moved to dismiss, saying, what about this disclaimer? The judge said, you can't disclaim because much of this information is purely in his own knowledge. He's the only one who has this information, and you cannot disclaim information you give over when you're the only one who has the ability to get it. What is this information that he alone has? This is some of the things that we should be thinking about. Oh, really? This information that only Trump has when he's coming up with these valuations that there's no way they could have? Yeah, apparently Trump alone has access to Zillow. The banks didn't have access to that. Trump alone is able to figure out how many units are on a property. There's no way for the banks to figure that out unless Trump tells them the truth on that. Trump alone is the one who knows how many floors are in a building. No one else on the planet knows how many floors are in that building that's fully occupied. No one else knows how many floors are actually in that building. He alone has that information, and that's why it's not fair for him. That's why he can't rely on this disclaimer clause, because the banks had absolutely no way of looking into this on their own. So that's why the court needs to intercede here and protect these helpless banks who got paid off every penny of what they were asking for, because that's what we need a judge and an AG to do. So that's what this case is about.
Is it really 34 degrees up there?
I haven't been.
I don't know. I'm looking at the little weather thing down in the bottom right.
Oh, yeah, now. Yeah, I guess so.
Yeah, you can have it. I'm down in Florida.
All right. We again I'm probably not going to ask you much about brand value. Your attorneys are free to ask you about brand. Yeah, of course, because that actually would inflate the value of these properties. Now, so I'm going to pretend that there's no such thing as brand value. That if you have two properties that are identical in very similar situated property locations, your two properties that are identical, and one of them was owned by Trump and the other was owned by Joe Smith, that those two properties go for exactly the same thing, right? There's no extra value that no one would pay extra just because it's where Trump lived, right? No one will pay an actual penny for that, right? Okay. We going back to the I'm probably not going to ask you too much about brand value. Your attorneys are free to ask you about brand value. Going back to the estimate.
Excuse me, sir, but if I wanted to build a statement like you said that I would before, up and found out exactly how rich you were, I would have added brand value here, and they would have increased it by tens of millions of dollars.
Do you have an understanding of whether a statement of financial condition prepared under GAAP is allowed to include brand value?
It's an asset. Coca-Cola includes it in big other companies, public companies. I think they all include brand value. And I became president because of my brand. I sell books at levels that are incredible because of my brand and so many other things. And if I wanted to build this statement, like you're saying, they would have been surprised. I'm sorry.
You were very surprised.
You were very surprised. Words are important. You were very surprised when you saw the real numbers. And now you go a different way. You changed your case midstream. If you wanted to build my financial statement, all I had to do is add brand value to my financial statement. It would be very, very substantial.
Mr. Wallace, did you ask for an essay on brand value? He did. He said
it's like
he asked whether GAAP is allowed under brand value. So, did you ask for an essay on brand value? No, Your Honor. My question was, and I will ask it again, Mr. Trump. Do you have an understanding of whether a statement of financial condition that is prepared under GAAP is allowed to include brand value?
I think it is because public companies have brand value. Coca-Cola has brand value.
And did you ever discuss with Mr. Weisselberg whether or not, under the rules of GAAP, you were allowed to include your brand value on the statement of financial condition?
No, because I didn't care about it. I didn't care whether we added it or not. It wasn't something that was important to me. If I wanted to build up my numbers in a fake way, which you're trying to say, but now you are not, maybe you were going a different direction. But I didn't care enough about it to bother with it.
That was a yes. That was a yes and no question. It could have been answered yes and yeah, it could have been. He didn't have to.
But it was like a Trump yes or no answer.
If you received such a question. So the statement was primarily prepared by Alan Weisselberg, but you can see here where the judge is just, what the hell is just.
Yeah, the judge is totally gunning for Trump here.
Yeah, I mean it's so apparent that it's astonishing. So the statement was primarily prepared by Alan Weisselberg and Jeff McConney. Is that correct?
Yes.
And they would give you a copy of the statement. Is that correct?
Yes, at some point.
And you would, in fact, review it. Is that correct?
Yes, in some cases.
And as we just discussed, the only example you remember of an asset being higher than you thought should be was your apartment. Is that correct?
There were a couple of other things. I just don't remember. You were talking about a lot of years ago.
It's actually not at all what he said. He said Mar-a-Lago is higher. He said a bunch of them. He said Doral is higher. He said 40 Wall Street's higher. I don't know what he's talking about. There were a couple of would you discuss the statement with Mr. Weisselberg?
Very little.
When you say very little, what discussions did you have with Mr. Weisselberg about the statement?
I would look it over. I may have a suggestion or something, but very little. It wasn't very important. You have made it important, but it wasn't important. It wasn't important financially. Most developers don't use accountants for this. They just take a piece of paper and they write the name of the building and the address of the building and what they think it's worth. They don't go through all of this. I don't believe any developer, at least that I know of, has done a statement as so thorough as this. And frankly, so lowball as this statement is much less valuable in terms of the dollar amount than the actuality of the wealth or the worth.
All right, so I think they switch over court reporters here, which is not really relevant. So this statement was prepared in a manner that you agree with, that you think was appropriate.
That was fine. It was fine. I didn't go into great detail on it, but it was fine.
If anything, you think the statement undervalued your assets. Is that correct?
Well, I do by a substantial amount. It was the opposite of your case. Your case was that I had no money at all. I mean, looking at this year, what could I have 300 some odd $1 million based on saw 300? Let me look. But phony statements and the defrauded banks, and even
You
though
sued me.
I'm sorry, I have to read all of the words. I
scrolled on you. I scrolled on you, so that's why.
Yeah, it's all good. Hold on 1 second. Hey, for what it's worth, I've never done this before, in front of 500 of our friends.
Right.
And what you're the hell doing, Joe? Reading the 2 or 3 other parts and then offering commentary between them. It's pretty damned awesome. And I don't know that people appreciate quite how difficult that must be. I know I'm having a hard time just reading sentences in front of me.
They practice. It comes with practice.
Yeah, it's like rah Joe. All right, let's have some fun. But you sued me on the basis that Trump had no money and he wrote up phony statements and defrauded banks, even though they were represented by the biggest law firms in the world and the most sophisticated of the best lawyers. And even though these banks were paid back in full, there was no harm. There was no anything. Everyone got their money in full. There was no victim. And then you were saying I deferred it. The banks don't even know what they were doing in the case. They said you paid us back.
Sorry, I had a little problem.
It's down here. You paid. Sorry.
Yeah, sorry. I had a little problem. I had a problem with my own.
Have a little fun.
No, I had a problem with my tabs here. So it just were playing weird. Your Honor, I move to strike that answer. Granted. Mr. Kais, can you control your client? This is not a political rally. This is a courtroom with a case about executive law section 6312. I've asked the witness several times to answer the questions. I don't want editorializing. We'll be here forever and we'll accomplish nothing. Maybe you should have a talk with him right now. Your Honor, I'll do as you instruct. You're in control of the courtroom, not me. And I don't mean that disrespectfully. Truly, I don't, but I'm happy to do as you instruct. Again, we're dealing with an extraordinarily unusual situation here. Again is a bad word. I know it is. I know it's part of the record. It's an extraordinary situation. It would be most efficient ultimately to allow the explanations. It's a bench trial. I disagree. Talk to your client for a minute. Okay, then should we take our 10-minute break? And I can't do it here. No. Do you want to go in the back? If we're going to have a conversation, I would ask Your Honor to give us a 10-minute break. Will you spend the 10 minutes in the back explaining the rules here? I think the former and, again, soon-to-be chief executive of the United States understands the rules.
Wow. Wow. The former and the, again, soon-to-be chief executive. Jesus Christ.
Wow. That's his way of basically saying to the judge.
He's going to get reelected anyway. So why?
I think that the former and soon-to-be, again, the chief executive, that is beautiful. That is so
fired. You're so fired.
No, this is a way of him being put me in your cabinet.
Oh, Jesus. Yeah, right.
He doesn't abide by them. I'm happy to do as you instruct. Again, I think Mr. Wallace's questions still are very broad questions. They do call, in some sort of senses, they call for narratives. So I'm happy to restate my last question, Your Honor, and to see if we can proceed. The last question was, if anything, do you think the statement was undervalued your assets? Is that correct?
Yes, by a lot. The financial statements. Yes.
Would you discuss the valuation of individual properties with Mr. Weisselberg and Mr. McConney?
On occasion. I disagreed.
If I disagreed. Yeah, in other words, the point is, he only would bring it up if he disagreed with what Weisselberg and McConney did. That was the point.
But only on occasion.
I guess. Yeah.
Yeah. All right.
Do you recall discussing with Mr. Weisselberg and Mr. McConney the valuation of Mar-a-Lago?
No.
Would they ever ask your opinion about the valuation of 40 Wall Street?
They might. Yes.
Seven Springs?
A little bit. It was done largely by a big law firm who had testified, as you know.
You're referring to Sherry Dillon?
Yes.
Sherry Dillon did the valuation of Seven Springs?
Yes, very much her transaction. She was at a very prestigious firm, one of the most prestigious firms.
One of the best firms. It's one of the most prestigious firms.
Everybody says so.
Everybody says it's one of the best firms. I think you already said it, but did you not consider the statement of financial condition to be an important document, correct?
Whoa, bro. It's nice to see, but it's not very important when it comes to borrowing money. As I think you've learned, I'm very underleveraged, relevant to the asset value.
I wasn't here for this part. I'm so curious whether he said levered or leveraged.
I can't imagine he said levered. God, no way.
Why was it nice to see?
It's a compilation. We'll use that word that you've been using for 2 weeks. It was a nice restatement of assets. And you could go up on some and down on some, but it was nice compilation of assets. It's a great statement, particularly the year you picked. I had essentially $342 million worth of cash. It's a lot of cash. Some people borrow money for tax purposes because you can deduct interest and other reasons, but it's a lot of cash. The banks came to me. They wanted to make deals with me. They liked me very much.
Very much.
Very much.
Graph to gain money or advantage to see. Oh, this was back when you said they claimed that he would have had to pay higher interest if he didn't inflate his numbers. But again, the banks never made that claim. Joseph, Joe doesn't deserve our praise. Yeah, that's right. I don't deserve your praise.
Well, you get my praise.
No,
I
thank
mean,
you. See this?
Yeah,
look at this judge. Look at this judge. He gives a thing. He gives the banks came to me. They want to make deals with me. They like me very much. Stricken.
Yeah, it's like well, there it is. It's not so very.
It is
stricken,
no objection. He's just striking. This is just unbelievable.
That's
it's
like
really
such an
unbelievable
asshole move.
He is. I mean, I might say that if he wasn't a New York judge.
No, they're elected in New York. That's right. You can't talk about them because you're a member of the New York bar. And
stricken once he got into the last sentence or two. Yeah, Anna, I would ask it be stricken after the statement. It was nice to see. It was a nice restatement of assets. Well, or it was a nice compilation of assets. I don't mind the part about how much cash he had, so we'll end it after that. Yana, again, noted Mr. Wallace's question, why was it nice to see? When lawyers are in depositions, they ask questions like why. That's what they do. When they get to a trial, usually what they do is ask more focused questions. Or they sit at counsel's table and don't ask questions and they throw up a bunch of ridiculous questions. Mr. Wallace, are you done? I'm just trying to make a point for the record. And that is, if you ask open-ended questions, then he can anticipate open-ended answers. And it's not fair to put all this on the witness. I understand your Honor's instructions. I think the witness does. But if you ask a why questions are usually in depositions, not in trial, unless you already know the answer. The open-ended questions was about why it was nice to see. I did not ask about the cash on the record. It's not relevant to the answer. I think that's the issue. Oh, here we go. Alina Howe. It's absolutely relevant. That's his opinion. Sorry. I'm not trying to do you dirty, Alina. But I gotta try to find some way to distinguish. It's absolutely relevant. That's his opinion why. When you ask a witness why, they're going to give you an opinion as to why. You now stated your objection. I'm being filibustered by the witness and counsel. I would like to proceed. Okay, just proceed. Going back to the work of Mr. McConney, Mr. Weisselberg, you understood that they were making a good faith effort to put down the value of properties. Is that correct?
Yes, I did.
You understood that they used common sense to prepare the statements. Is that correct?
I hope so. I don't know, but I hope so.
And as we stated, if anything, you thought the valuations they reached were too low, correct?
Absolutely. Well, that's been proven.
Okay, let's go through a few of those valuations. If we could turn to page 8 of this document, the top we see, this is the Nike Town property. If we look at the middle paragraph here, the third paragraph, it says, quote, the estimated current value of $348,800,000 is based on an evaluation by Mr. Trump in conjunction with his associates and outside professionals, applying a capitalization rate to the cash flow to be derived pursuant to the building's net rental stream. Do you believe that statement to be true and accurate?
No.
How is it inaccurate?
The net rental stream is one way, but the bigger value is the holdup. Well, it's not a nice term in real estate, but it's called holdup value. I'm directly with that site and behind. Oh, wait a minute. I'm directly with that site and behind and next to the fifth, next to on 57th Street.
He's describing where the property is.
Yeah. Oh, I see. I get it.
With
Yeah,
that site and behind and next to on 57th Street.
Right, which is probably the best location, the best location on 57th Street. It's the best location in New York. I'm directly on Tiffany. They cannot expand without us, and I'm directly next to IBM. So I'm between IBM and Tiffany. And the holdup value is $348 million for holdups, Probably what I mean, if you know real estate, it's peanuts compared to what the value is.
Just pause for a second.
Yeah,
what he's trying to explain here is this.
The geography here.
It's not that you can get by renting out these properties, the $348 million that's valued there, but the holdup value is this. That there's an expectation that Tiffany's or IBM, who's right next door, is going to want to expand into his space. And he can basically hold them hostage, hold them up like a bank robber. That's why it's not a nice term. He can basically be a jerk about it, and he can push them as high as $348 million if they come to him and they're looking to expand. That's how much he thinks that he'd be able to heist out of them, even though the property itself as is not worth it as far as what you can rent out. That's what he's trying to explain here with this lengthy answer.
So I view that as it's a great property. It's a great rental stream, as you probably have figured out, but it's got much more value as a holdup. They could come to me and offer me $500 million for that site in 2 minutes if they wanted to expand or if they wanted to do something.
The statement, however, is that the estimated current value as of June 30, 2014.
Yes.
So the $500 million price you just referred to, that's as of today, correct?
No. I would say it would be as of any time. It's just it's
so what he's trying to say here, because now what Wallace is trying to pin him on is you're trying to say that based on now, but that's not what it was worth back then. And Trump is like, no. That holdup value is what it was worth if they would have come to me back then. That's what it was. So that's what Trump is not giving in on, and wisely not giving on that. I'm not asking for further explanation.
It could be any time. It could be then. It could be now.
So there's no change of value of this $500 million value since 2014?
Well, I don't want to sell it. If I wanted to sell it, I had discussions with Tiffany for years about the possibility, do something. In fact, they rented from me now for a lot of money. But if Tiffany used, as you know, as you possibly heard, when Tiffany was rebuilding their store, they came to me and they wanted to do something. And I leased it to them for a period of time. But they would love to be the owner of that site. My point is a holdup. It's not a nice word. It's a holdup site. And holdup sites in New York have made.
The question was, has there been a change of value since 2014? You said, I don't want to sell it. So I take it the answer is no.
No, I think it's gotten more valuable like everything else.
So do you not think that the statement in your 2014 statement of financial condition is accurate, correct?
Well, it's a great rental stream, but I think real value here is the value it would be for IBM or Tiffany if they wanted to say, and they do, at least Tiffany does.
This statement says the estimate was based on evaluation by Mr. Trump in conjunction with his associates and outside professionals. What was your role in preparing that valuation?
I think I mentioned to them the value of that is it makes a lot of money, throws off a lot of money, as you see, because you see the numbers. And now more than ever, because Tiffany had to pay us a lot of money in order to lease it. I just wanted to lease it. We gave them a 5-year lease while they built their store. Their building, as you know, they just opened, but they would love to own it. And so would, I believe, IBM. I don't talk to IBM at all, but they can't expand without it. I believe that. I did mention quickly, I didn't know if this wasn't something I devoted a lot of time to, but I mentioned to them there is tremendous holdup value on that site. Again, 57th Street. If you have, I'm sorry, there's no if there. You have Tiffany, IBM, you have my building right in the middle of them. And if they want to expand anywhere, they have to go through my building. And I bought the air rights.
Hold on.
Excuse me. I thought I bought the air rights over Tiffany, so they can't go up.
In addition to the answers being non-responsive, they're repetitive, and we don't have time to waste. We have 1 day with this witness. Mr. Kais, can you control your witness, because I am considering drawing a negative inference to any questions that might be asked. What the hell?
Hey, Joe, I think I know the answer to this. What the hell are the air rights? Right? He's not obviously not talking about aircraft.
No, so air rights in real estate basically mean the building is 4
so many stories high.
Yeah, but the air rights basically mean that you have the right to build above it, as opposed to someone can sell you a building and retain the air rights, which means
so you sell me a 5-story building, I can't make it a 6-story building without your permission.
Correct, because I retain the air rights. And you also might, someone might be able to, if they can get zoning, they might be able to build out over you.
The building next door.
The building next door might build out over you if they want.
The big overlooking restaurant or whatever.
Whatever, yeah. So that's all part of the air rights. Anything above the building as standing currently is called the air rights.
So Trump's saying he's got the air rights here?
Yeah, he's like not only do I have the building, but I have the air rights also. So if they want to build anything, if they want to move out in any direction at all, even if they're a taller building, even if they're in theory. If he has a 20-story building and they have a 90-story building, they're not allowed to build up on the 50 floors above him, because he has all the air rights. So that's what he's saying. Basically, he's basically saying that he has them by the cojones, and that they must deal with him if they want to expand. If they want to expand in his direction at all, that's why he's saying that.
Sounds like a pretty valuable right to have,
Yeah, no, and in New York City, worth a lot of money, as you can see. As you can see, I think the former soon-to-be chief executive of the U.S. is like that scene in Man of Steel when Superman allows himself to be handcuffed for a bit. Yeah, get Chandler Remington to read Haba. She's a pro at doing these dramatic readings.
Hey, the more the merrier.
I don't know if she's around. Yeah. But my point here is the court is ridiculous here. I mean, this is just astonishing. He's going so above and beyond. You can understand why his counsel is so frustrated here. So Mr. Kai says, well, I would urge your honor not to draw the negative inferences. We have a record on that, which I won't go into, but I think the witness is doing his best to answer the questions and be as responsive as possible. If you think that it'd be beneficial for us to take a break, I'm happy to do that. This is your honor's courtroom. So I'll do is she keeps saying that, which is basically like when attorneys call another attorney counselor. It's like, this is your house. I follow your rules, because that's what we as attorneys, we litigators know, that when you're in their courtroom, you're in their, it's like being in the king's court. You have to do whatever. He's the king of that domain. So, and it's important to make sure that they can't draw any connotation of disrespect from what you're saying, because that, you're under his thumb at that point in time. This is your honor's courtroom, so I'll do as you suggest. But again, the questions are calling, maybe not as broadly as the answer, but they're not tight questions. I mean, we're seeing why questions. We're seeing how questions. I mean, this is not someone who's a professional lawyer or witness. So he's answering based on his responses and the reactions to the questions. Mr. Trump, You testified under oath many times, correct? So now Wallace, who's the one asking the questions, is basically trying to show he knows what he's doing a lot more than you're pretending, Mr. Kais. Mr. Trump, you testified under oath many times, correct?
Yes.
The question was, what did you do based on an evaluation of Mr. Trump in conjunction of his associates and outside professionals? And you said you talked to them about the hold-up value. Is there anything else you didn't prepare in this valuation in 2014?
No, I don't think so.
Did you ultimately approve this valuation?
No.
Did you approve the issuance of this statement?
I think they did something with it because when I told them about the hold-up value, they said, well, you're right.
Who's they?
The people compiling the statement. They couldn't have been Mazars, too.
It could have been Mazars.
It could have been Mazars, too, yeah.
Did you?
It didn't make a big deal. I didn't make a big deal.
I didn't ask you if you made a deal. I'm asking if you told Mazars about the hold-up value for the 2014 statement of financial condition.
It's a long time ago. I probably did, but I told Jeff and I told Alan. And
okay, do you believe that the stated value of $348 million was based on true and accurate information? He keeps asking the same stupid question.
Right. Well, as a hold-up, I think it's very low.
I'm not asking about the hold-up. I'm asking about whether you have an understanding whether this valuation, your statement of financial condition, was based on true and accurate information. It's a yes or no question.
Well, I say it differently. I wouldn't sell it for that number. If somebody offered me that number, I wouldn't sell it for that number.
I'm not asking your individual valuation. I'm not asking for an analysis. I'm just asking if whether the information that Mr. McConney and Mr. Weisberg used was true and accurate when they reached this number.
I guess so. I really can't answer that. I guess so. It's a number that I wouldn't sell it for.
Okay. Can we move down to the bottom of this page? We have the header for 40 Wall Street. And if we flip over to the next page, we'll see evaluation for 40 Wall Street. The top paragraph says, the estimated current value of $550,100,000 is based upon a successful renegotiation of the ground lease and an evaluation made by Mr. Trump in conjunction with his associates and outside professionals of leases that have been signed or are currently the subject of negotiation, and a capitalization rate applied to resulting cash flow to be derived from the building's operations. Do you believe that statement I just read is true and accurate?
I don't believe. It depends on how you look at it, but I don't believe it talks about the making of the building, the condominium, a residential condominium, which is absolutely a perfect use of that building.
My question is,
even though it's full,
is this statement true and accurate?
Well, let's see. So number one, you go back a long time. Are you still in 2014?
We're still on the 2014 statement.
5-year statute of limitations. You are still in 2014. So it says here, based on successful renegotiation of the ground lease, that was done. I did that. I made a new 100-year lease, and that very good lease, a long-term, very long-term. I got a lollipop in a lease. It's a legal term. Believe it or not, it's a lollipop, which allows you to build condominiums because you own the land. You own a piece of the land. That gives you the right to build condominiums. So this would be a low number, because the highest and the best use of that building is, I think it's the tallest building in downtown after the World Trade Center, but there's a dispute about 60 Pine Street, but whatever. The tower is the perfect measurement for turning them into condos. And I have the right to do that. And I have some point somebody will do that. That's the highest, the best use. In which case, 550 million is a very low number. All you have to do is a picture of the bill. All you have to do is look at a picture of the building and say, that building. You just look at it and you say, that's worth a lot more than 550 million. If you want to put up that picture.
My question is, Mr. Kais, that was a simple yes or no question. I don't have it right in front of me, but the question was whether he believed that was an accurate number. We got another speech. I would beseech you to control him if you can. If you can't, I will. I will excuse him and draw every negative inference that I can. Do you understand that? I certainly understand, Your Honor. But I will say this. The purpose of this trial is to determine the veracity of the statement of financial condition, in part to figure out whether there is intent. So I would think respectfully, Your Honor, of all witnesses would want to hear everything that this witness has to say by way. No, I do not want to hear everything this witness has to say. He has a lot to say that has nothing to do with the case or the questions.
Well, that's true.
Which, by the way, I think this is the quote where she said, where the court reporter took down as everything. I think that he actually phrased it as, I don't want to hear anything the witness has to say. Meaning, I think that this is like, the court reporter seems very generous to Judge Engoran. And you'll see it later that there's a quote from him that everyone in the room heard and the court reporter never took down, which is, don't do it, Chris. That statement is not anywhere in this transcript.
Is there an audio recording of this?
No. But every one of us heard it. We all tweeted it out like right away. Like, can you believe he just said, "Don't do it, Chris"?
No shit.
It's nowhere in this transcript. Nowhere, which is astonishing. But I think, look, court reporters have a habit of cleaning it up for attorneys that they like or don't like. It's not unheard of if it's something that seems relatively innocuous and not so important, but that's a glaring omission. And I think that when he said, I don't want to hear everything, I think that he actually said, I don't want to hear anything this way.
Well, who fights for the court reporters?
And the reason I say that, court reporters,
the court reporters step on the wrong side of the street like anybody else does, right? And someone's going to say, well, wait a minute. That's Joe. And Joe's been my court reporter for 15 years. Who's going to make that argument? Who's their advocate?
Against them?
Well, who's the court reporter's advocate? When a court reporter has any transgression of any type.
Well, he or she would have to have an attorney.
Well, but the court reporter works in the court. I guess what I'm getting at is, I presume the judge who favors the court reporter is going to just by social deference keep anybody at bay who would want to throw a barb at the reporter.
Oh, I mean, if anything, the judge would do that. But I'm saying court reporters handle depositions also. So, so a lot of times, many attorneys have an issue with, they'll say a lot. If they don't like the attorney, every and gets, or those filler words get thrown in there. If they do like the attorney, they get sliced out. It's how conscientious the court reporter wants to be, and the court reporter can be a little bit of a dick about it by basically throwing in like. That's
what you typed. That's what you said.
You said it. That's my job. I'm doing my job here.
Doing my job.
Sometimes you think to yourself, man, I think the court reporter might have thrown in a few extra there. But the reason I think that this court reporter was ridiculously kind is I'm just going to pull up from his decision. From his own decision, because they addressed this, that he made this statement that he doesn't want to hear anything from the judge, from Donald Trump,
from Donald,
in their motion for a mistrial. And this is his decision on that. And over here he says, to the extent the defendants argue that I've exhibited bias by stating in court that I'm not here to hear what Donald Trump has to say, he didn't say everything, everything. He took out the word everything. Everything helps him a lot. It sounds a lot less awful when he says, I'm not here to hear everything he has to say. I don't think he ever said the word everything. I think he's probably said anything or left out the word altogether. Because if the word everything was there, and the judge explains, it says, such an argument is disingenuous and made in bad faith. To defend submitted, I said immediately after that sentence, which is, I'm here to hear him answer questions. So that's what we're up to over here in the deposition. I don't want to hear everything this way. Why is this court reporter put the word everything in here, but the judge somehow left that out? To me, the word everything helps the judge, makes him look more favorable.
Or at least more interested in the truth.
Right. And just not wanting to hear BS. But he didn't put that. And that's why I'm saying I think this court reporter, I think what he actually said was anything. Yeah. I think when you look at Alina Habba's statement, she goes, what he said was, I don't want to hear anything that Donald Trump has to say. And she came out blistering in news reports saying that's what his statement was. I don't want to hear anything this witness has to say. And that says everything you need to know about this trial. So he took out the modifier altogether, just said, I want to hear what this witness has to say. And the court reporter did one better by saying everything. Anyway, no, I don't want to hear anything this witness has to say. He has a lot to say that has nothing to do with this case or the questions. Again, Your Honor, I have to say that you're determining what's going to happen here. So I would urge the court to take in all the information possible, including what this witness has to say about the numbers on the statement, what he did, why he did it. I mean, all these circumstances. Do we really want to come back here in a few weeks and go through it that way? I mean, with this witness, I would suggest it's far more efficient to listen to what he has to say and take it in, and then you have an understanding of what he has to say. And I don't think it's fair to draw negative inference because of his explanations, simply because he wants to explain why he got to where he was. We're talking about 10 years ago. And so I ordinarily, with a witness, you might think differently. But this is a situation where you have on the stand a candidate for presidency of the United States. Having him here takes away from that effort. And so the most efficient way I would submit to the court to get through this is to listen to what he has to say. And then you can weigh it one way or the other. I don't think you should respectfully draw a negative inference. And again, I'm happy to discuss this and take a break. More than happy to do that. I'm not saying not to do that, but I would just like the court to take in the perspective, because this is a different situation. It's an unusual situation, and it would be most efficient. The court needs to hear what he has to say about what happened with the statements and why he thinks they're viable and why there is no intent. He's describing to you why there's no intent to mislead anyone with his answers. That's what he's doing. And so I would think that's highly relevant and highly probative. If you want to do it the way where we have yes or no questions, and then we go back and do it that it's subject to your direction. But I think it's the most efficient way to listen to what he has to say. I'm happy to talk to him about making the answers more contained. We certainly don't want to waste any more time than necessary and spend any more time than necessary. But this is, as you've acknowledged, this is a unique situation. If I may also ask, Your Honor, I had to cross-examine Mr. Cohen. If I can get him to answer the questions in yes or no, I advise Mr. Wallace to look at that cross-examination. It was far more succinct. The reality of the situation is he put up 2 paragraphs which talk about interest rates, the current value, as well as tenants, et cetera, et cetera. But if you would like to narrow it, then you narrow it. But President Trump is answering about 40 Wall Street and the values, the interest rates, the purpose of the SOFC. This is absolutely relevant. So I'm going to push back and say it's time to start pushing back on the AG. Kevin can try to ask better questions, and then we'll move on. But he's relevant. He's talking about 2 paragraphs of information. He's explaining them. Ask some questions. You'll get succinct answers. Well, Mr. Kais, I think you said several times we should hear what he did, what the witness has to say. No, I'm not here, and these people are not here, and the Attorney General is not here to hear what he has to say. Oh!
Really? I'm sorry, why are we here?
We're here to hear him answer questions, and most of the time he's not. So that's what they're saying that his follow-up was. So I stand corrected. Court reporter, I apologize if I maligned you. This is the actual quote here. He goes into speeches. It's very simple. Is this an accurate number? We don't need a whole speech. It's not that simple. I apologize. It's not that simple, and you're here to hear what he has to say. No, I'm not here to hear what he has to say. Thank you. So, yeah. So why is it that he says here that he followed up with, I'm here to hear him answer questions? Okay. I'm here to hear him answer questions. Sit down already. Mr. Kais, Ms. Kais, Mr. Kais, Ms. Haba, sit down. Mr. Walls, continue. This is back on you now.
Oh, I'm sorry. The witness.
Yeah.
This is a very unfair trial. Very, very. And I hope the public is watching it.
Mr. Trump, what was the valuation presented here based on your leases and capitalization rates, true and accurate to your belief?
It could be, but again, I told you, is a building has many different forms of value. And this building, the most valuable asset here is making it into condominiums. That would be, it would happen as soon as interest rates go down and as soon as the city maybe comes back. It would be nice if it came back, wouldn't it? But the value is, the big value of this is making it into a condominium, a residential condominium.
Could we put up
It would be one of the biggest jobs in the city.
Plaintiff's Exhibit 635? It's already in evidence, but I have an extra copy for the witness. There's a very thick document. I'm not going to ask you to go through all of it, but it's an email from Jeff McConney and Jack Weiselberg, Ladder Capital, attaching a modification of the ground lease. The email is dated April 10th, 2015. If you go to page 3 of this document, I'll put it up on the screen for you. You could see it at the top. Title says, "This is a resume of the 4th modification of the ground lease on 40 Wall Street, New York City." We flip over to page 4. Do we have a copy of this document for the witness? He has a copy. I'm sorry. It's already in evidence. If we look at the header, condominium conversion right, it says paragraph 4 eliminates the tenant's condominium conversion rights, which he had under section 2709. Do you recall that in this amendment to the ground lease, your condominium conversion rights were eliminated?
No, because I have a right to do a co-op. You could do a condo. You could do a condo, but I have the right to do a co-op. I believe I have a right to do a condo because we have a lollipop clause, but I have a right to do a co-op.
If you're wondering what a lollipop clause is, so am I.
Yeah. YouTube rules.
What is a lollipop clause? That's a good lollipop. Let's see if I can find something that makes sense. I'm gonna put in real estate.
Hey Joe, I'm gonna step away for 2 minutes.
Yeah, I'll keep reading. All right. It's an escalation clauses in real estate, I think. A lollipop clause. I don't know. He's using language here that is not really very apparent to Google. So, yeah. All right. If we go back to the statement of financial condition, that's Exhibit 730. We're on page 9. Did this valuation include the lollipop conversion that you were talking about? I don't know. It was around that time. I renegotiated the lease, and we got a new lease. And one of the things in the lease was a lollipop conversion. My question is about this statement, though, which says, quote, that the valuation is based on leases that have been signed and capitalization rates. There's no mention here of converging to condos, is there? Well, I know that you're asking. You're talking about the estimated current value, and the estimated current value would be a co-op condo. I'm not asking about what you could do. I'm asking about what was actually prepared. I don't know because I didn't do it. Okay, what was the stated value? Let me ask, did you approve of this valuation? I accepted it. It was just one of many. This is a very big statement. I have many different things, and this is one of the many values. I accepted it. I didn't say, oh, gee, it should be higher or lower. And you approved the statement's issuance? Yeah, I accepted it. Other people did it, but I didn't say make it higher, make it lower. Was the $550 million valuation here based on true and accurate information? I assume so. If we can go back to page 20 of 26 here, and if we see at the bottom of the page is the listing for the mansion at Seven Springs, I'll direct your attention to the paragraph. First sentence of this listing says, an entity wholly owned by Mr. Trump acquired a property known as the Mansion at Seven Springs in Bedford, New York, which consists of over 200 acres of land, a mansion, and other buildings. This property is zoned for 9 luxurious homes. It has been valued at $291 million based on an assessment made by Mr. Trump in conjunction with his associates. So the projected net cash flow, which either derived at those units as those units are constructed and sold, and the estimated fair value of the existing mansion and other buildings. Do you have an understanding of whether that $291 million valuation is true and accurate?
I thought it was too high. And we lowered it, I guess the next statement or sometime, but I thought it was too high. But this is the equivalent of Mar-a-Lago in New York. And I think it sells for, I think it's valued. I think the value is higher if you don't build additional housing. This is it's a magnificent place. This is the kind of place that somebody will pay a lot for. I think more money than if you build 9 or 16 or 20 units of other homes on the site. I think the site, as I remember, is 213 acres. And I think this is much more valuable, actually, without the building. I think it's more valuable the way it is.
Your Honor, I think maybe we need to take a break now. And if Mr. Kais could talk to the witness, I think I would appreciate it. Let's take how long a break would you suggest? Make it 15 minutes so it's easy, a 15-minute break. Thank you. I'll direct the witness not to talk about the case or his testimony than in the ways that I've asked. And so it went. Now they come back here 15 minutes later. I get Shapiro's never Trump strategy now. Lose 2024, let it go horrible, then be able to vote for a real libertarian like 2028, like Argentina.
Have you seen any of the interviews with this guy in Argentina?
No, I haven't.
He's on fire.
Is he?
Yeah. What about the liberal this and what about because they're shit? Because they're shit. You can't give them an inch. They'll take them. He makes Trump look tame.
Really?
The guy is on fire. I mean, of course, what I saw was the translations. I don't speak Spanish,
right?
But he's not. No, he's not being nice about it. He had Shapiro did a video with him of him. He's got a whiteboard just crossing off departments and government agencies. Agency of this gone, agency of that gone. You know, just really baller stuff. This he's not worried about making friends.
It's not the worst Trump ever. Mine is the worst Trump ever. If someone feels
I
thought you were doing great.
I'm having fun with my friend Joe on the stream.
Yeah.
I'm not trying to.
I think you're doing awesome. Okay.
But if anybody wants to jump in, you know, and I wouldn't take it as a challenge.
Yeah.
It's not a challenge. It's like I'm hanging out with my friend Joe, having a beer, reading through this badly. And if anybody else wants to jump in, come on. It's fun.
It's all good. Yeah, don't shy away. Don't shy away.
No, the more the merrier. I would be happy if somebody came in and did a better job than me.
Anyone Rumble sitting here saying that they want to jump in? Anyone at all?
That's fine.
If you think I miss you, send $1 super chat, and I won't miss you, and I'll
capitalist pig.
So Debbie explains New York Times Lollipop condo is a legally separate resident built on top of an existing apartment building named for the general shape of a real estate. Oh, so thank you. That's helpful. But I think you're doing great. So
I don't know. I'm just like I said. I've said it already. So
yeah,
stop saying it.
Mr. Wallace, please continue. Thank you, Anna. Mr. Trump, when we broke, we were looking at the valuation. By the way, I'm trying to sound like those.
Is your nose okay?
It's from
what happened there.
I'm doing the guy from The Simpsons, who's like
Quagmire. No, that's
the guy, the lawyer, but not Lionel Hutz, the other lawyer, like who's always the prosecutor.
Oh, geez.
From The Simpsons, like the one, like whenever
you're out boomering me, Joe.
Oh, stop it! It's still on TV. Mr. Trump, when we broke, we were looking at the valuation for Seven Springs in your 2014 statement of financial condition. I believe you said that the valuation you said eventually dropped that valuation. Is that correct?
Yes.
Did you eventually take a tax deduction based on the easement donation for Seven Springs?
I believe so. Yes.
You recall receiving appraisal showing that the total value of Seven Springs before the easement was $56 million.
No, I don't know. It could have happened, but I don't remember.
Do you remember if the easement appraisal was the reason for dropping the value of Seven Springs?
No. The person that did that, I believe, was Sherry Dillon. That was the law firm that we mentioned, and a very good one, a very prestigious, and she really was responsible for doing it. It was sort of, I think, her idea to do it.
So when you say the person that did that, that you're referring to
easement
is the easement donation itself?
Yes.
So if you did not decide to lower the value of Seven Springs based on the appraisal from the easement donation, what was the basis upon which you decided to drop the valuation?
Well, I thought it was high. I mean, I thought that. Well, I saw it was a statement. The statement was, wait a minute. When I saw it.
When I saw the statement.
When I saw
it, the statement
was done. Yeah, English words.
Well,
yeah,
I think a comma there that
yeah.
got cheated out of.
I got to read Queens a little more often.
Yeah, when I saw it, when I saw it, the statement was done. And I said I thought
that I thought it was high. All right. And that was one of the ones that was high. That doesn't mean it's not going to get that kind of money, because that's the kind of place that would get that kind from the right person. But I thought it was high, and they dropped the value.
And so, in your view, the estimated current value of Seven Springs as of June 30, 2014 was not 291 millions. Is that correct?
I thought it was high. Maybe I'll sell it for more than that. I don't know. With that kind of property, you never know. But I thought it was high.
Is the Seven Springs easement donation under review by the IRS?
Not that I know of. It might be.
Well, was it at any point under review by the IRS?
I don't know.
Do you remember when you decided to lower the value of Seven Springs?
Well, I guess probably when I looked at it, I don't know if I looked immediately upon, because again, I haven't spent a lot of time on these statements because I realize the value of these statements is not that important. But then I looked at it. I thought it was high, and I said, you have to lower it.
So the answer is no. You don't remember when you decided to lower the value.
I don't remember. It might have been immediately, but it was, within a period of time.
If we could turn to page 21 of 26, this is the section of your statement of financial condition entitled Partnerships and Joint Ventures. And there's a reference to a joint venture that is 1290 Avenue of the Americas in New York, and 555 California Street in San Francisco, California. Are you familiar with these properties?
Yes.
Underneath that, it states, in May 2007, Mr. Trump and Vornado Realty Trust became partners in two properties, 1290 Avenue Americas, located in New York City, and 555 California Street, formerly known as Bank of America Center, located in San Francisco, California.
Mm-hmm.
If we look down a few more paragraphs, it states, Mr. Trump owns 30% of these properties. Is that accurate?
Yes.
And so you do not control the partnership with Vornado. Is that correct?
In many ways, it's better because I have no liability. I am a limited partner. That's limited liability. I have 30% interest, but my interest, I don't have to put up any money. I didn't put up any money, and I don't have to. I have a very good relationship with them. They are great and very professional. But it's also limited. It was limited. I had no liability for what I own. So it was a lot of people don't understand that. All right, yeah, that's weird.
Mm-hmm.
I'm reading that going, is that weird? That's weird.
It is.
Yeah. They think that a limited partnership gives you limited rights. In this case, it gives me limited liability.
The question was, so you do not control the partnership with Vornado. Is that correct?
I have 30% of the partnership, yes.
And so you do not control the partnership.
In the true sense, no. I will say this. We have a good relationship, and
very good relationship.
A very good relationship.
No, you answered the question.
And never had a problem.
And we appreciate that it is the true answer. Thank you. The next paragraph states the estimated current value of net debt, value net of debt, is $816,900,000. Is based on an evaluation made by Mr. Trump in conjunction with his associates and outside professionals. Is it true and accurate statement that you value the property based in conjunction with your associates and outside professionals?
I don't know, because I'm not familiar with the number. But I do know that, as you know, the one building is the Bank of America building. One of the best building on the West Coast. And the other is a very great building in Manhattan on 6th Avenue of the Americas. That's what I said.
Yep.
We refinanced that building 3 years ago at a very, very low rate. And there were valuations placed on it then. And if you want, I can get you that information, but the valuations were very high.
The question was whether you made an evaluation in conjunction with your associates and outside professionals of the value of those two properties.
I don't know. It doesn't sound high to me, not for those buildings. So I don't know.
So I'm going to ask it again. The question is whether or not you made an evaluation of the property value.
Is that a double property right there? Is that both properties?
Both properties.
It doesn't sound high. I don't know if I was involved in that. I remember looking at it, but it didn't get my attention. I think it is worth more than that.
Hold on a second. Let me just pull up. I had a couple of super chats. So I just
Yeah, do the super chat thing.
yeah. Thank you for being you, staying true to yourself, and not going cuckoo like many in law. There's no such thing as law too. You're a force multiplier for intelligence and common sense. Well, thank you. Thank you very much, Della. Monk says, God is truly hidden that they can get away with dragging him through the mud like this. Anything to destroy America and its champions. This is sadly too true. Debbie says, I was with my father for a year while he was selling a commercial building, and 0 people were willing to give a valuation beyond what the rent was. Commercial real estate is only worth what someone will buy it for. The appraisal was 100 pages with a range from 0 to 10 million. That's it. All right. And that's, I think a lot of it depends on what property you're talking about. I mean, it depends where the commercial real estate is. It's, if it's Manhattan, everything, it's not like there's, it's not like you just, build something else on Fifth Avenue. Whatever's there, it's there. So I think I'm not disputing what you're saying with respect to commercial real estate in general, but I do think that Manhattan is fairly unique in that respect.
It's peculiarly, it's corrupt.
Jenny, thank you for the super sticker. Much obliged. All right. Do you remember playing any role in evaluating the estimated current value of these 2 properties for any years between 2011 and 2021?
2021?
Correct.
You mean bringing it back to
all the way for the last 10 years? That 10-year period.
By the way, that was the hottest period ever for office properties. So I think you should know that, and you don't want me to talk much, but I think you should know that. No, I think the value sounds reasonable. I don't know. I doubt it. I don't know that I would sell my interest for that, actually.
I'm gonna hand the witness the document and ask the officer and excuse sorry, this is you.
And excuse me, the businesses have been refinanced 2 years ago.
There's no question pending. Mr. Trump, I have handed you a document that has been marked as Plaintiff's Exhibit 3344. This is an email from Jeff McConney to Donald Bender entitled Ferry Point. It is dated October 1, 2012. Your Honor, I ask this document to be entered into evidence. Objection! Statute of limitations! Overruled. It's in evidence. At the top, there's an email from Mr. McConney to Mr. Bender. It says, Doc, I'm almost done revising last year's footnotes. Alan wants S to speak to DJT tomorrow about the Vornado buildings. I'm going to send you a few emails with some info on new properties, Doral and Charlotte, and an update to the Scotland footnote. I want to ask if this refreshes your recollection about whether you had any conversation with Mr. McConney and Mr. Weisselberg about the value of the Vornado properties.
About the Vornado buildings?
Correct.
No, but I probably did.
If we can go back to the statement of financial condition, if we can blow up this section with the valuation there, the estimated current valuation, the amount of debt, Mr. Trump, do you believe that the stated value here of $816 million was based on true and accurate information?
I think so. I hope so. I can say if you go to 2021, where it is more familiar to me because it's more updated, I think that would be a low number.
Were you involved in the preparation of the 2021 statement?
No.
Who was responsible for the preparation?
I don't know. That was when it was in trust. So I assume Alan and Jeff and perhaps they dealt a little bit with Don and Eric, but they were not involved with these statements very much at all, as I understand it.
Would you get copies of the statement in 2021?
I hadn't seen it. I was so busy in the White House. My threshold was China, Russia, and keeping our country safe.
My question is actually about 2021. Did you see a copy of the 2021 statement?
I don't believe so.
And just to clarify for the record, you weren't president in 2021, correct?
No, I wasn't.
Actually, he was. In fact, a lot of people make a big deal about that. He was president on January 6, 2021.
Like that was like the whole thing, right? Because he was still president, right?
No, I'm doing the voice from the Simpsons. If that there's a lawyer
making the prosecutor sound like the mob. Well, the prosecutor does sound like the mob.
Yeah, seriously.
And stop it.
If we could turn back, if we go to page 23 of 26 in this document, and if we look at the bottom of the page on the category of other assets, it says Trump Tower. Mr. Trump owns a triplex apartment on the top 3 floors of Trump Tower. See note 3. I'll just represent to you that note 3 doesn't discuss your apartment. It discusses the building. Were you involved in the valuation of the triplex apartment for the statement of financial condition?
No. What date is this?
2014.
No, I wasn't.
Did there come a time when you determined that the valuation for your triplex apartment was too high?
Yes, I did.
After you made that determination, did Mr. Weisberg and Mr. McConney lower the valuation of your triplex apartment?
I believe so. Yes.
Did they do that at your direction?
I told them I thought it was too high. I thought the number was too high, and I know they lowered it after that. Yes.
If we could pull up Plaintiff's Exhibit 758, this is a spreadsheet, so it's only going to be up on the screen here. If we go to row 893, this is a category other assets. And if we look down, if we go down to rows 969 and 971, this shows the valuation of your apartment. I'll represent to you that the valuation of the apartment is not actually in the statement of financial condition. It is incorporated. So this is where we're going to try and find it.
I'm sorry. I'm still like processing a spreadsheet with 1,000 rows, and somebody sat and flipped through all of these rows and went,
Yes.
aha,
Yeah.
look at that.
Yeah.
Aha,
Yeah.
969 and 971. We got the bastard. Really?
So sad, isn't it?
Oh my God. Maybe we jump off a bridge. I'm sorry. I think that's why I missed it also. Well, there you go. That's my freaking point.
Yeah, because 969. And it could be a 10,000 row thing for all we know.
Yeah.
Okay, and if you look, you can see here, I'll represent to you that column G are the values for 2013. Column H is the value for 2014. So you can see that it goes from 116 million in 2013 to 327 million in 2014. And so is it your understanding that the 327 million valuation is too high?
Yeah. And the reason I didn't pick it up sooner is that I thought it was high, but it's not mentioned. It is not broken down in the financial statement. So I wouldn't have known.
Okay, and I'm sorry, apparently this is the statement of financial condition for 2017, so I misrepresented.
That's okay. That's okay, Joe. Nice try. You can stay.
I remember when this happened in court when he said that's okay. So like the whole room like just broke.
Like pats him on the head.
The whole room, like, yeah, it's like he's like, don't worry. It's like, I forgive you, okay, Mr. Wallace. That's okay. The 2017 number is in G and the 2016 number is in H, so I apologize. Sorry, just to make the record clear, Kevin, this is the backup, not the SOFC. Correct. I think you said the SOFC on the record. And this is the backup for 2016. 2017. So showing a change from 2016 to 2017. It is very confusing which freaking years they're talking about here. And this change in valuation came at your direction?
Probably. I mean, I thought it was too high, but I don't know what is too high anymore because I'm seeing things being sold at numbers that are very high. But I thought it was too high, so I assumed that they didn't.
Do you have an understanding why the valuation was too high?
Well, I've heard different reasons, but one of the reasons was they did it off a broker. A broker was sending lists of apartments and they had it down to 30,000 feet. Is it 30? And another one was, I have the roof. We have access to the roof, which is very big. And when you add the roof, it's not that far off. And there are a lot of other reasons. And there is another reason. They just made a mistake. And that's why we have a disclaimer clause in case there's a mistake. There is a disclaimer clause where you don't have to get sued by the Attorney General of New York.
Mr. Trump, as you sit here today, do you know how big your triplex apartment is?
You wouldn't know. I've heard, obviously, because of the trial, they say 11 to 12, 13,000 feet.
At your deposition testimony, does it sound correct that you testified that each floor of Trump Tower is about 10,000 square feet?
as the floor and its triplex. And I think they probably took 10,000 feet per floor. I could see how it was done. They took
See, this is
10,000.
another thing that they're
Right.
claiming that he alone had access to. He's the only one who knows how many square feet there are on each floor of his triplex apartment, which is asinine. You can pull up the building's records and see
I mean, for
how big
crying,
each
crying
floor
out loud,
is.
the building has length and width.
Yeah, yeah, yeah. That's
So,
that's why
um,
it's so infuriating that the judge basically said, "Well, the disclaimer is not good because he was disclosing information that the bank had no way of verifying absent whatever he told them. They were totally dependent on him, so his disclaimer doesn't count." It's
eh,
like this is how many square feet there are on a floor in a building.
right,
Like
right.
you pull up the building plans, you know how many and you take out for the elevator
And it's
shafts
not
and
like you
stuff.
can put a freaking hanger on the damn closet in a building in New York without asking for a permit. So any bank would be able to pull records, because if there's going
In
to be a
2 seconds.
partition in
In
that
2 seconds,
in that absolute square footage of the building,
they could
the,
probably do it
the
from their office.
maximum length and width of the floor, if someone's going to partition it from one huge suite to
Mhm.
two smaller suites or four smaller suites, there's a record.
Well, it's
And if the suite
when
gets a
the building's
closet,
built,
it's
there's
a
a
record.
record. When it's modified, there's a
Everything, there's a
record.
record for
Everything,
everything.
there's a record,
That's
and it's a
right.
public record, and
So it's
that's
not.
why it's
Yeah,
it's
this is
asinine.
not like in some small town in Wisconsin somewhere.
Even if it was, there's always a record. We're very careful. We're very careful about our land records.
In New York, imagine that.
Joe, forgive me saying you don't deserve our praise as cult leader supreme. We are in your town. Don't worry about it. So I didn't take any offense. By the way, there's a whole bunch of super chats that I missed
No, read a bunch of them, dude, bro.
in locals. So
Oh,
fan
all
says
hail the
expand the window
locals
of forward
diggers.
to remove the thumbnails. This is for the sound guy. You now owe him $1. That's not happening. Viola says tips for our favorite digger, Joe Sound Guy. Fan says why courts not do audio link transcripts to include tone as well. We live in modern age and our court's still living in 19th century because he doesn't want anyone to see this. That's what Engoran's feeling is. And he says, I bet their audio recording used to make the transcript. No, that's unlikely. That's unlikely. This is almost certainly from the court reporter who's sitting in the room. So
Now, Joe, you're a New York attorney, so you can answer this. Like, if you went in there and recorded this surreptitiously, if you had like some secret pocket recorder,
I'd have my license suspended.
Okay, so that's not going to happen.
Right. No one's doing it. No
until you're ready to go jump on a sword professionally. It's not
for no real upside. Yeah. Yeah. It's suicidal. You're basically, as a New York attorney, going into a New York courtroom, flouting the court's authority where they have express rules all over the place that no one is supposed to be recording anything or transmitting anything directly from this room. For any New York attorney to do that, you'd be fast tracked. If they learn about it, you'll be fast tracked to having a suspended license or worse, and arguably could be held in contempt of court. You would be so wickedly punished for that, and properly so. I mean,
it makes sense. I mean,
it's a betrayal. It's a betrayal of your role as an officer of the court.
Totally. Now, let's go crazy. California attorney comes in to straighten out those crazy people in New York, and he surreptitiously disobeys the order from some faraway state. I pick California, but it could be anywhere.
It could be New Jersey. So the question is, so what they could in theory do is they could report it to the state bar that the person is from, and ask them to take action against them for ignoring the rules of the court. It's unlikely they would go to that length, but that's definitely possible if they felt like they're a real betrayal. And the question also is whether you're subject to the jurisdiction of the courts when if I go to Iowa, I never set foot in Iowa, and there's a trial in Iowa that I go to and I start covering it. Am I subject to the jurisdiction? And one could make a case that in order for you to be subject to a court in general, any rules or any law of the state, forget about a court, any law of this state, the court has to have personal jurisdiction over you. And the only way they can obtain personal jurisdiction is if you are deemed to have purposefully availed yourself of that jurisdiction. And you could purposefully avail yourself of something and be deemed to have purposely availed it in all respects or in limited respects. So you could, in theory, when you're driving cross country And if you get into an accident and you're driving, let's say from Florida to Washington to Oregon, and along the way you get into an accident in Kentucky. So you're deemed. So now the guy wants to sue you in Kentucky. You say, I have nothing to do with staying in Kentucky. Kentucky courts have nothing to do with me. So it's well established case law in America that the site of the accident is considered the best location and is the primary, and that you have purposefully availed yourself of the roads of Kentucky when you went through there. So for purposes of that accident, you could be sued. Now, let's say somebody is mad at you from the state of Kentucky. You got into an accident, someone's mad at you in the state of Kentucky, and they want to sue you in Kentucky. And you say, I'm not part of Kentucky. They're like, well, you got into an accident here and you were held into court for that. We want to hail you into court for this completely unrelated thing that you probably could not be held into court for, because it's not related to your use of the state of Kentucky. So similarly, by extension, if we take that thought and we say, okay, now I'm going to Ohio to stream a trial from there. And so I have no ties to Ohio other than the 3 days I go in there to stream a trial. But for purposes of any wrongs I commit in streaming that trial, one could arguably say that they have limited jurisdiction over me because I've been purposefully availing myself of Ohio to the extent needed to stream the trial. So if the judge in Colorado, if I went to Colorado and was streaming from there, or if I'm theoretically using her stuff, now it's getting closer and closer toward me purposefully availing myself of that jurisdiction and subjecting myself to whatever rules and govern that locale. That makes sense?
Yes.
It was a little.
What are my options here?
Yeah, okay.
All right. You must be so much fun at Thanksgiving.
Yes, I am. Yeah. So this is why Lady Logic never asked me a law question.
Uncle Joe, I got a fender bender, but it was like on the New Jersey Turnpike, but I just crossed the. Yeah, I can imagine.
Look, some people I'm sure got my meaning out of what I was saying there, but if you were too tired after reading so far 70 pages with me, I get that. I get that.
No, my wife came home.
Oh, nice.
She got off work. She came in, so I was able to hit mute and like go say, hi, honey, how are you? And she told me about her day, and I told her what I've been doing for the last 2 hours, and she told me, what happened at work and what happened at 7-Eleven. And then I came back and you were still talking.
She read to you War and Peace. And
then War and Peace. And I came back and you were still talking.
Like, Jesus, Joe. Jesus.
It's like, oh, mute. Hi, honey. Oh no, it's okay. He's still going.
No, it's fine. He's just blah, blah, blah,
blah.
Hopefully actually, there's not a test on this later.
Well, I started this right because I kind of the thing you missed is, wow, this judge seems like a tyrant. Oh my gosh, how can he get away with that? Oh my gosh, is there any way to push back for anyone in the country, really, whether it's a local attorney like yourself or some citizen reporter somewhere else, to come in and push back against the crazy judge? In principle, right, we all want to rebel against the crazy judge. We want to push back and go, the judge is nuts. We can't let that judge do the nutty thing. But I think it's a worthy conversation to have, because we're not trying to burn the building down. We're trying to
up to the first department to punish him. Meaning, there's 4 departments. New York State is divided up into 4 departments, and the first department governs New York City and the Bronx. He's practicing. His court is in Manhattan, so he's part of the first department. The appellate division of the first department, Office of Court Administration, there could, in theory, there could be repercussions that would come from them. But
right. I'm just thinking about it from a layperson.
The chances of that happening seem remote.
I'm just thinking about it from a layperson's point of view, because in this case, it's New York. It could be a crazy judge in Ohio tomorrow, or in Kansas, anywhere. When the crazy judge does those crazy judge things.
Yep.
How does the machine work to push back against the crazy judges?
It doesn't really work to push back on the crazy. It's very, very difficult. It's very difficult. They're very well insulated. They're
Wow.
very.
And I guess to some degree that sort of makes sense
Mhm.
because you want them to have the latitude to make their decisions free of ridicule.
I guess. Good evening, everybody.
What has just happened?
Sorry,
oh my gosh.
that was an echo here. I was going into my chat here because what I wanted to do was I wanted to put a link to my Trump trial place, my Trump trial, because I'm going to be shutting down Good LAWGIC channel. I need to.
You mean on YouTube?
On YouTube, I'm going to stay on YouTube. I'm going to stay on Rumble.
Right, but the YouTube
I want
channel.
I want to motivate people to look at my other channel, which is Trump Trial, and I also need to ratchet up the hours for that in order to be eligible for monetization.
Well, the way we're reading this, they're going to have plenty of time.
Yeah, well, so that's why I'm definitely not going to make it all the way through this tonight. I mean, this is
cult follower number 6 just put a link in the chat.
Yeah, so I just put a link. Oh, it's called followers. I beat you. I beat you the punch and pinned it already. So
where do you think I got the link from?
Oh, okay. That's good. So you can't find it on the YouTube TV app. I'm not sure what to tell you, old drill sergeant, but I'll tell you that I did put it in the chat and it's also in the description. So I'm going to urge you guys, if you can check out over there, it looks like this over here. See, it's all happening here in Trump Trial, which right now there's 89 people watching, and I'm urging you guys to start switching over there because like in 5 minutes or so, I'm going to shut down over here and I'll be streaming on Rumble. I'm sticking on Rumble, and I'm going to be streaming on Rumble and Trump Trial, but I'm going to be shutting down from YouTube. I'm going to be shutting down Good LAWGIC. So you can keep watching me on YouTube, but the rest of this streams like 5 minutes from now. We'll work a little further in here. Give people a chance to and if you can, while you're there, if you can like and subscribe, I would be much obliged. Yeah,
I don't know what it is about your channel that keeps you under 100K, because you've been under 100K for, I don't know,
my whole life.
Oh, stop it.
Well, it's true.
For too long, you know, it does look artificial. It looks wrong.
When I pull up, I went through the numbers and I pulled them up. I think I did it on Locals, where I went through my viewers up or down per day, and I had like a period of like 150 days in a row where I lost between 6 and 20 people every single day, which you lose it on one day, like 9 people. All right, it's 9 people out of like, tens of thousands. You don't really notice that. But when it happens every single day, first of all, it means you're not getting any growth no matter what. And new people are not finding their way here because YouTube doesn't put it into their recommended feeds no matter how many likes I get. And when it starts getting cumulative, when you start losing 15 people every single day, that's 400 people a day. So over a couple, you end up losing over a couple months, you lose 2,000, 3,000 subs, and you're basically going like nowhere. And that's
it's almost like YouTube knows that.
Yeah, it's struggle's been real.
I read a great book the other day, and one of the things I took from it was good decisions compound. Bad decisions compound. YouTube withholding your subscribers
compounds. Yep. Let's go a little further here before I shut down on Good LAWGIC channel. All right.
Sure.
All right. Mr. Wallace, I would like to go back to the 2014 statements of financial condition. F it. Oh, sorry.
Wow.
F it. If I could,
your nose got in the way.
Go to page 10 of 26. That's probably a typo. This is the heading for club facilities and related real estate. So when we scroll down, this is the listing from Mar-a-Lago. If you look, I'll read it to the record. It states, Mr. Trump acquired this property in 1985 and transferred ownership to a wholly owned limited liability company in 1995. It is now an exclusive private club which consists of 117 rooms. Formerly known as the Marjorie Merriweather Post Estate, it features a 20,000 square foot Louis the 14th style ballroom, world-class dining, tennis court, spa, cabanas, and guest cottages. I'm going to direct your attention to where it states as the property is an exclusive private club. Is that correct?
Yes.
Okay. And is it correct that the ownership of the club was transferred to a wholly owned limited liability company in 1995?
I guess so. If you represent, I would say yes.
Well, if I'm asking if you know whether or not the representation here, which is that it was transferred to a wholly owned limited liability company in 1995. Do you know if that's correct?
No, but it's probably so because I have done that with many properties over the years.
Is Mar-a-Lago today still wholly owned? Is the ownership of Mar-a-Lago today still underneath a wholly owned limited liability company?
I believe it's the same.
And there's no separate valuation for Mar-a-Lago on the statement of financial conditions in this century, correct?
You know, I have no mortgage on Mar-a-Lago, no debt. There is no debt. There was no reason to do it. So I don't know if they did it or not. But there is no debt, zero on Mar-a-Lago.
My question is just that the price of Mar-a-Lago, or I should say, estimated current value of Mar-a-Lago, is not listed here, is it?
No, it is not. It is not.
Okay, if we could pull up the supporting data for this statement of financial condition, Plaintiff's Exhibit 719. This is, I'll represent to you, the supporting spreadsheet for the 2014. Do I have this wrong? Okay, if we go down to row 189 and actually go down to the club facilities, sorry, 205. You see the entry is at 207 for Mar-a-Lago, and underneath that it says value if sold to an individual. That is referencing to selling the property to an individual as a residence. Is that correct?
Yes, that's right.
Did you approve valuing Mar-a-Lago as if it could be sold to an individual as a residence?
I personally, well, I did approve it.
Did
On
I?
this,
Did I approve it?
well, did I approve it? On this, I don't know. There are two ways you can approve it: as a club or as a resident or as both. Now, wait a minute. For fuck's sake. There's two ways: the first, the second, and the third.
Yeah.
So,
Yeah.
all right. It's most valuable as both.
And here it is being valued as a residence, correct?
I guess so. What is the number?
We'll get to the number in a minute. I was just wondering, did you at some point discuss with Mr. McConney or Mr. Weisselberg valuing Mar-a-Lago as a private home?
I don't remember that. No.
If we go down to just go to the bottom, row 242. Do you see a value listed for Mar-a-Lago?
Yes.
Is $405,362,123 as of June 30th, 2014. Did you approve that valuation number?
No, but I believe it's a very low number.
So do you agree with that number?
No. It is much more valuable than that. Much. But we're bringing in an expert so that they will explain it to you what it's worth.
I'll ask you a question.
How
you
much?
believe as of today, Mar-a-Lago is worth at least 1.5 billion. Is that correct?
How much?
1.5 billion.
I think between $1 billion and $1.5 billion. Yes.
As of June 30, 2014, though, do you have a view as to how much Mar-a-Lago was worth at that time?
More than this. I don't know, but much more than this number.
Mr. Trump, we're going to hand you a copy of a document that's already in evidence. This has been stamped as Plaintiff's Exhibit 1013. This is a deed of development rights for Mar-a-Lago Club, and I'll direct you to it up on the screen. If you could just turn to page 2 of the document just quickly. Do you see your two signatures?
Yes.
There. Okay. If we go back to the first page under the third whereas clause, and I'll read it into the record for you to highlight it here. It states, whereas the club and Trump intend to forever extinguish their right to development or use the property for any purpose other than club use. Now, this to explain to my audience here. There's a different valuation on property, whether it's a club or a residence. There are tax benefits. It's much, much lower taxes if it's a club. It's much more higher taxes if it's a residence. However, its market price as a private residence is considered much higher.
Is this the club with one resident? Or
That's where
club with
we're
one
coming
member?
to right now. That's where we're coming to right now. So what their issue is this. He's, in order to get the lower taxes, he signed off on it as it being a club, and then he intends to keep it as a club forever. And yet so that should be the lower valuation of the property. But when he applied for a loan, he listed it on a value based as a private residence, not as a club. So that's where they're saying is he's intentionally committing fraud. You're making a promise to the government that you're going to keep it as a club forever to benefit from lower taxes, and then you're going out and trying to use a valuation as a private residence because that'll help get you a better loan. So when you're going out to do that, despite promising the government that you're going to keep it that you intend to keep it as a club forever, that's the fraud. And they think that this is a big, huge point for them to win on. So that's why they're going in on this here now. And the way Trump walks through this is brilliant, like freaking brilliant.
Now, what did his son say about his ability to do real estate?
When
He said his father's ability to do real estate was like beautiful or delicate, or he had
it's art.
Yeah.
It's
He
art.
was an art in real, and it's like, bro, I mean, it's like, he's your dad. I get it.
No, but this is where he displays brilliance as to how to control real estate in a way to maximize its value. So continuing here with Mr. Wallace asking questions. It states, whereas the club and Trump intend to forever extinguish their right to development or use the property for any purpose other than club use, was it in fact your intent to forever extinguish your right to use the property for any purpose other than club use?
Well, when you say intend doesn't mean we'll do it. That's number one. It says intend. I intend, but we have the right to change it back to a house. I intend I would always leave it as a club or a club and residence, which is really the best combination, which was what it is right now. It is a residence and it is a club, and a very successful club at that.
I take it your answer was that yes, you did intend to do this.
Yeah, I intend, but I also have the right, if I wanted to. There's no reason to do that, to switch it back.
Switching it back would be contrary to forever extinguishing something, though, wouldn't it?
No, it says to intend. It doesn't say that. It says to intend. It doesn't say I will. It says intend. But I don't mind leaving it as a club. In fact, if someone actually wanted, the smartest thing to do, because there are a lot of advantages to the club status, the smartest thing to do would be to have the club and have one member. And that would be the member that lives in the club. But it is much more valuable, and we will show that in 2 weeks or 5 weeks or 9 weeks or whenever this thing goes, that it is the most, it's the biggest value to be, its biggest value is to be able to use it as the club and residentially simultaneously.
What he's saying here,
this is really like clever, super clever,
is brilliance. It's utter brilliance, and that's what he displays here. In fact, I'm gonna shut down over here on Good LAWGIC, and because I've already expressed this brilliance on Good LAWGIC before, but those of you who missed it, I mean, I'm going to be switching over now. The link is in the description. The link is in the description and in the chat for the Trump trial channel. I urge you to join us over there. I got a whole bunch of folks who are ready. How many are over there right now? How many over there? 142 watching there. I've got 726 watching. I don't even know whether that's combined or whatever, but yeah, so I'm going to urge you to join us over on Trump trial as I explain over there. This is what the channel looks like over there, and yeah, anyway, see, that's the delay that you're all seeing that thing slide around there. Anyhow, wow, this is so psychedelic. It's not going to look psychedelic when I get over there though. So okay, I'm shutting down. I'm still going strong on Rumble, and if you're on Rumble and you can hit like and subscribe there too, I'd appreciate that. But right now, I'm going to just shut down over here on Good LAWGIC, and I'll be back on Good LAWGIC, God willing, tomorrow evening. But so those of you on Good LAWGIC, I say to you, and who are not going to be following me over, I say to you, why? Seriously, dude, why? And hit us over on Trump trial on speed. And we are out of Good LAWGIC now. All right.
You know, I sent you a DM about this. You
Yeah.
have mods on the new channel.
No, I don't.
You ought to think about that. And I don't mean to be too self-serving, because I know I'm a mod on your one channel.
No, I don't mind. I'll throw you up there.
Well, that's great, and I'm happy to be one to the degree I can. But
This is gonna get.
you're going to need others.
Folks. I know I'm gonna need others. All right. Let me just add a few people in here. All right. We'll just make Joe rating Joe. It is Joe rating Joe. Joe's been here on Joe the whole time. All right.
It's all the Joes.
We're
This is the Joe channel.
gonna I'm just gonna randomly add moderators here to people whose names I recognize. Basically, those people who are paying members on locals.
Actually, that's a really smart way to add.
Yeah,
mods.
I figure someone who's paying to follow me on locals, they're probably. But
They
now
probably actually give a damn.
They're not gonna feel bad if I leave people out. So
why don't you just make a post in locals for members only, and explain it to them, and it'll be good. It's like, no, it's like I'm only human. I couldn't remember everybody, so I did this.
I suck at remembering, and also knowing the names from here to there.
Oh yeah, and usernames change and stuff like that.
So
just keep it real. The people who are watching you enjoy what you do, and I think if you keep it real with them, you'll be fine.
I'm doing my best.
Just don't jerk them around. If you don't jerk them around, you're fine.
I know. Ambell is digger. Who am I the diggers?
All hail the diggers.
Yeah, I'm trying to hit up the diggers. Where are my diggers?
Actually, look in the locals chat.
Oh, that's a good idea.
It's like, hey, locals people.
Yeah, locals people. Yeah, locals people. Give me your names.
I'm focusing on the chat now.
Yeah, I'm looking right now.
Now, and
I'm looking right now.
Minutes. You get in a few minutes because like the wife is going, honey, he's finally looking at the local chat. And somebody,
this is not true.
What? He's really looking at the local chat. He said, really, well, it's gonna be a minute. Why? Why would you ask me such a stupid question? I thought the doctor gave you something for that.
Hold on a second. Let me see. Let me
so give everybody a minute.
I need you to say something. I need you to talk in here. I need you to talk in both locals and on the chat here in whatchamacallit.
What do you mean? What do you mean whatchamacallit?
In Trump trial.
I'm in Trump trial. Am I not in Trump trial?
Yeah, I don't see you talking in there.
Oh, well, I'm only talking in the StreamYard link you gave me.
Oh, no, this is the same StreamYard link.
I didn't leave it.
No, I'm talking about, I need you talking in the chat.
Oh, there. you mean to make a chat? I'm sorry, I misunderstood.
Yeah, that's not on me. You're the one.
I'm sorry. Well, yeah, okay. Hi, all.
It's not me.
At Joe near me.
I saw Viola talking there a minute ago.
Oh, all hail Viola Pride.
Yeah, I saw Viola talking in there a minute ago.
You see, I talked in the chat.
Did you? Let me scroll down.
I did.
Oh, I believe you. Here's Viola. All right, let me get. Wait, where are you? There's Viola. Okay, let's get Viola as moderator. Stand moderator. Save. And I don't see you talking in that chat there.
I did. I just said all hail the diggers.
All hail. You said that in Trump trial chat?
No. Oh, well, I'm sorry. I misunderstood which chat you referred to. I'm sorry. I was in the local chat.
Right. That's not helping me. I click on a name in the chat on the channel as it's scrolling and just say hit add as moderator.
Are you good LAWGIC in the Trump trial?
No, I'm Trump trial.
Oh, okay. There you are. Oh, I see you now. You got a whole new name and everything.
Well, that's my they don't give me a choice.
I understand.
Oh gosh. Who else do I owe here? I'll tell you this. I think I'm
now a moderator.
You are.
Yeah, I even got the FAQ.
Garrett says not to moderate him. I think Wims is in there. I don't see Free Divine Spirit in there.
Yeah, I don't know if I've noticed her. Well, I've been reading.
Caldy is saying mod
What
me.
about the old drill sergeant?
Where's Caldy? Where's Caldy? Here it is. That is a moderator. This is such a perfect call. This is such a perfect call. What's Divine Spirit's name?
Oh gosh, I think of Divine Spirit and Locals. Oh geez.
No, on YouTube.
I know exactly. And you know where I would type it in? I would type it in your chat on the show you just closed.
Great.
I'm sorry, Joe.
You're a very big help.
I'm working on it. Let me check with our buddies and locals.
Yeah. And Big Boop, what's that? What's Big Boop's name in here? This is so confusing.
All right. So what we're asking for are what the YouTube names are of the users you're mentioning.
Correct.
At least the names in your good logic world.
Here we go. Here's triggered.
At Free Divine hurt herself. Oh, right. She fell and she may not be on YouTube. Oh, dear.
Oh.
Oh. Well, that's a damn shame. Get well soon.
Mm-hmm. All right.
Let's see. Caldy is saying mod me, baby.
I thought I modded. I did mod K though. Okay.
Big Boop. I'm not caught up. What's he saying to the diggers?
Oh my gosh.
I'm gonna reply to Big Boop. Message Joe in the.
Oh, here's Big Boop. Okay. I got Big Boop.
Oh, excellent. And you got Viola Pride.
I got Viola.
Fans? Did you get fans?
Yeah, I got fans under some weird name, which I don't remember, but it was and here's Divine. That's what I was looking for. Divine. All right. Okay.
And B?
I think I got in.
Okay.
Yeah, I did. I got in, Bill. Yeah. I think Wims also is.
I mean, I understand this kind of like totally breaks the show flow.
Yeah.
To give the love to the diggers.
I give my love to the diggers.
I mean, if you're going to break the show flow,
I see. I knew Wims was in there. See, I knew it was. It's good. I post on X today. Pamelio, are you on? Are you in Trump trial chat? I'm trying to add all these people here. All right, let's get back into our thing here.
We are doing a thing.
Yeah, we are doing a thing. I think the Rumble people are gonna get mad at me. They'll be like, "What the hell's happening?"
Well, if the Rumble people joined locals, it would be easier.
That would be.
Or I know they're YouTube phobic, and that's cool. That's their thing.
That is their thing.
But if they were part of this new YouTube channel, it would be easier.
That would be a little.
So there's more than one venue. Then
yeah. All right.
And Rumble's great. So
yeah.
What else can you do to?
It's great for what it does.
Maybe what you should do is create a second Rumble channel too. That way,
both
your heads explode.
Oh hell no! Hell no! All right, let me let's get back into like our thing here. I think we're good for now. We're good for now, right? So
we spread a lot of love around.
I got Wims. I think I spread a lot of love around. Yeah, I spread a lot of love. If I missed you, I apologize. If I missed you, I apologize. All right, I'm doing my best. I'm definitely gonna hit.
No, you're doing a hell of a job. I mean, I'm sitting here and I'm reading like less than a third of the text, and I'm struggling along.
Yeah, no, it's very confusing. It's very, very confusing.
Right, and it's like I think I heard snippets of this, and you're like reading the other 2/3 and commenting on the legal references and the meaning, big picture and little picture, and managing the show. And doing all the production and pushing the buttons and being a boomer and all of that shit.
And those of you who are new to modding, I just want to be clear with you. Just remember that you understand that my rule is basically the same as I have over on Good Logic channel. I don't want, just because someone might be disagreeing with me or with you, please do not abuse your status as a mod to time them out or silence them. What I'm asking you to do, please, is unless they are spamming, and spamming is not simply talking in all caps, because some people have eye issues or whatever, but if it's the same message over and over again, or essentially the exact same thing with very little, that's spamming. Or they're breaking terms of service, or they're being racist, or they're breaching YouTube terms of service. What is breaching YouTube terms of service? I don't know. I have no idea beyond what I already expressed of spamming and the other stuff. I don't know. I guess merchandising or whatever, selling, marketing stuff. That could be, I don't know. Talking about crypto or anything. I don't know. But yeah, those are the 3 rules. Unless they're doing any of those, please. You might tell someone to chill out or something like that. Please don't just start banning people, because I'm really a big fan of free speech. So let's get back into it. You ready? Oh, so I was about to explain to y'all what the brilliance, the genius of this answer. The genius of this answer, and what he said over here, when he says over here, he goes,
super genius.
Yeah, the smartest thing would be to have a club and have one member, and that would be the member that lives in the club. The genius in what he's saying here is this: you pay lower taxes if you list it as a club. You can have it listed as a club, and say, you just have to say you intend to keep it as a club forever. Now, a year later, 2 years later, 10 years later, 20 years later, 50 years later, you might change your mind. But there's really no reason to ever change your mind. Never. There really isn't. Because then when you sell it to someone, you can have yourself as being the only member there. And if you're the only member there, it's like a one-man club. That's kind of a house. That's a residence right there. So if you're the only member of the club, so in that case, you're now paying lower taxes. He found a tax loophole to get around having to pay higher residential taxes and pay only club taxes while still having just a private house, because it's a club with one member. So why would anyone want to take it out of that kind of club status? Now, I guess if Florida changed their rules and said a club has to have a minimum of 20 members, something like that, in order to qualify as a club, I guess at that point he might change his mind. But right now, given their current rules, their current laws, they're basically saying, hey, if you can basically qualify as a club, I don't know, maybe you have to have a ballroom, maybe have other stuff you have to build there, whatever it is, but you have the proper amenities to qualify as a club, that's the best kind of residence to have, where it's a club and you're paying lower taxes.
So this is what you might remember this to the audience. You might remember this from the Hillary debate.
Mm-hmm.
But if you don't remember from the Hillary debate, you probably remember it from Chappelle.
Yep.
Who made the joke about it.
That's right.
Saying, because I use it. I know that the tax code is rigged, or the system is rigged, because I used it. Mm-hmm. And so do her donors, and so does this, and this seems like
he's using the tax code.
It's exactly that. It's a completely fits that whole skit.
And they're trying to say your property is worth a lot less. And it's like, no, it's not worth a lot less. If anything, it's worth more than any of the other residents, because I'm paying less taxes than those other suckers who are not qualified as a club. It's worth way more. So I don't care that people list it as whatever. If someone's actually coming to me to buy the property, I'll walk them through why it's listed as a club and why it is that I'm selling it at residence prices, and how they should be thanking me for having it qualified as a club. Yeah, they never should change it from being a club. Just keep it as a club with one member. They'll be happy. Anyhow,
so yeah, and the valuability show weeks 5, 9 weeks, whatever.
But these disingenuous New York leftists are basically like, oh, you see, he's being fraudulent. No, he's working within the system that the left created. That's essentially what he's doing. If we it's not really the left, the truth is, because honestly, I mean, in Republicans, it could be Republicans in Florida. This is back in 1995. I don't know who was running the state in 1995, because it was really purple in the 90s. As you saw, it was back and forth on Bush and Gore. So I can't tell you who actually, and those laws could have been written 50 years before. So I can't tell you that was really written by the left. But whatever the rules were, he read the book, he read the code, and he's like, this is the way to do it. And it was genius. If we look at the next paragraph, it states, whereas the National Trust for Historic Preservation in the United States is the grantee of the deed and conservation reservation easement recorded on April 6, 1995, an official book record, blah, 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 the book records, as reflected here. You had, in fact, granted a preservation easement to the National Trust for Historic Preservation in 1995. Is that correct?
That's correct.
If you look down the next paragraph, it says, whereas the preservation easement limits changes to property, including without limitation, the division or subdivision of the property for any purposes, including uses of single-family homes, the interior renovation of the mansion, which may be necessary and desirable for the sale of the property of a single-family residence estate, the construction of new buildings, and the obstruction of open vistas. That's what it says, right?
Yeah.
As reflected in the 1995 preservation easement, then it was prohibited to renovate the interior of the mansion in a way which may be necessary or desirable for the sale of property as a single-family residential estate. Is that correct?
It was a single family home. It was a home of E.F. Hutton and Marjorie Merriweather Post. I don't think anybody would want to touch it. It is designed as a home, and it was converted to a club very successfully, and it does great. And that's where it is. But this, I feel like I'm screwing what you're scrolling now. But this is, you don't have to do anything to convert it. And also, the easement really talks about views. It's only a views easement.
A view easement.
A
Meaning
view
that there's an
easement.
easement that you can't make the place look ugly by putting up things that'll block the view. That's what
If
the easement
if
is.
I want to build something, I go to the National Trust. I built a ballroom as an example. I built a very big ballroom. The ballroom you mentioned in your last page was built by me. It was very large, beautiful. And what happens is, if I want to development, wait a minute, if I want to development, holy
Yeah.
Trump, Jesus Christ, bro. Other parts of the property, but not the view corridor.
Meaning the part that's listed as a view that you can't block.
Yeah, that's kind of whack.
That's
Right.
probably the accurate term, though.
Yeah. I guess in real estate it might make sense. Right?
Yeah.
Anyway, it's called a view corridor. It's a certain view corridor from the main windows of the living room. But on this side, what is called the side corridors, I have the right to develop if I want to. But this is a little valuable.
It's a little like we're talking
a
about.
little like what we're talking about about Seven Springs. This property is more valuable without building houses on it. It's much more valuable, actually, in this case.
After this deed of development rights, you stated publicly that Mar-a-Lago will forever be a club, didn't you?
That is what?
You stated that Mar-a-Lago would forever be a club. Is that correct?
No, I don't think so. I mean, it says intends. I would personally never change it if someone later on including my children, if they want to change it, I believe they would have the right to do that if they wanted to.
Mr. Trump, the court officer is handing you a document that has been marked Plaintiff's Exhibit 1730. This is an article from the Palm Beach. This is hilarious. The Palm Beach Post dated August 27, 2023. And if you look at the bottom of the page, there's a quote from you. It says, "We waited until it became a great success," Trump said, "and the Mar-a-Lago Club is a great success. It will forever be a club." That was your statement, correct?
Yeah.
In 2003, the Mar-a-Lago Club would forever be a club.
Well, I hope so. I mean, I think that was said with bravado as opposed to with legal intent. It'll be for you, and as long as I'm around, it will be a club. And I live here.
And by making, I apologize for interrupting.
Oh, yeah, please.
By making sure it was forever a club, you paid less in taxes on the property. Is that correct?
A club will pay less in taxes, correct?
And that says that. If we look at the fourth paragraph here, it says, "We pay less tax," Trump said Tuesday. "Now we are treated like a bath and tennis and other clubs."
That is correct. Pay less taxes. Not too many clubs. You pay much less tax.
Your Honor, I'll ask that this document be entered into evidence. It's like we want to enter into evidence the genius of Trump that we're going to pretend is corrupt.
See, but that doesn't exist until appeal.
Yeah. For what purpose are they introducing the document? He has admitted that these are statements at the time. So all of his statements in here will be admitted. Now, this is the weirdest thing, that they want to get in a statement that he said to a newspaper. So? Like, what the hell does that prove? So he says something to a newspaper, so that means now he's bound by that.
Right,
10
just
years
like every
later,
other
20 years
politician.
later. Like some stupid thing he says to a newspaper reporter, like, "Oh, we got you. You said it to a newspaper reporter."
And Joe Biden graduated at the top of his class and went to
Yeah.
college on a scholarship.
The statements of Mr. Trump only. It's in evidence. The statement where he says if it didn't work out as a club, it would go back to some other use. That's acceptable as well. The one you didn't show the witness, the one on the bottom. I'll ask him about that then. Yeah, you should. Mr. Trump, if you look at the second to last paragraph on the page, we'll highlight it for you. It states, if it didn't work out as a club, we could have gone back to some other use. Is that accurate?
I believe so, yes.
I believe Your Honor has overruled the objection that this is in evidence. Is that correct? Yeah, the entire document is in evidence. Mr. Trump, I'd like to hand you another document. This one is marked as Defendant's Exhibit 478. Mr. Trump, in order to win approval to convert Mar-a-Lago to a club, you took the position that it was impractical for a single individual to continuously own Mar-a-Lago as a private estate at his or her own sole expense. Is that correct?
Yeah, probably in those days. That was a long time ago.
Well, I can show you. This document is the Mar-a-Lago. If we turn second page, please.
Sure.
It's Mar-a-Lago Club Special Exception Use and Preservation Plan. Do you remember submitting this plan to Palm Beach in order to convert?
Yes, I did.
Your Honor, we asked that Defendant's 478 to be marked into evidence. Granted, it's in. If we look at page 6 of the document, I believe it states at the top, as to item 1, I'll represent to you that item 1 is private ownership of Mar-a-Lago. It states, it is impractical for a single individual to continuously own Mar-a-Lago as a private estate at his or her sole expense. When the Post Foundation marketed the property after its return to the foundation from the U.S. government, it was almost impossible to sell. About 80 qualified buyers thoroughly screened, inspected Mar-a-Lago, and elected against even making an offer. H. Ross Perot was one prospect, although it's so crazy the circles he's running in, you know.
It's that large sucking sound, Larry.
H. Ross Perot. H. Ross Perot was one prospect. Although everything is for the sale at a price, no one would step forward to make offers for this so-called white elephant, and cites to articles in the Miami Herald and the Palm Beach Post-Times. Is it correct? Was this statement correct at the time it was made?
Yeah, I got lucky.
He definitely said lucky.
Well, I got it luckily.
I don't know. Who knows? I take it now your position is that no longer a white elephant?
That's true. There's a man building a house down the road, spending $1 billion to build it. And it ain't Mar-a-Lago. They are spending $1 billion down the road.
If we can go back to the statement of financial condition, that's Exhibit 730. Mr. Trump, I'd like to focus on your golf club, Aberdeen. So we can go to page 16 and 26. Here we see the listing for Trump International Golf Club in Scotland, Aberdeen. I'm just going to read into the record the description of the club here. It states, Mr. Trump, through wholly owned entities, acquired 500 hectares, approximately 1,236 acres of land on the northeast coast of Aberdeenshire. The development received outline planning permission in December 2008 for world-class Martin Hawtree Design Championship Golf Links golf course suitable for hosting major events, a second future award-winning 18-hole course, a luxury clubhouse, a state-of-the-art driving range and golf academy, a tennis center, an equestrian center, a luxury 5-star 450-room hotel with associated conference and banquet facilities, and a full-time spa, a residential village consisting of 950 holiday homes and 500 single-family residents and 36 golf villas. Start there. Was that description of the club as of June 30, 2014 true and accurate?
Probably, but we could do more or less. We could do a bigger job, a smaller job.
Do you believe it was accurate that as of December 2008, you had received outline tenant permission for residential village consisting of 950 holiday homes?
Yeah.
And 500 single-family golf residences and 36 villas?
Yes. Aberdeen is the oil capital of Europe, very rich.
Irrelevant. You answered the question. Stop supporting.
Wait a second. Stop that.
Supporting,
stop right there. What the hell?
Proof of what you're saying.
That's like timeout. Irrelevant. You answered the question.
Yeah, you could have just said yes.
I mean, like, all stop.
Why?
Whatever you do, don't answer the question.
Yeah. Yeah. Yeah.
because it could be irrelevant if you
He's
answered.
he's
Jesus
twisted.
Christ, it makes me
Yeah.
want to jump off a bridge.
It's pretty sick. It's pretty
Yeah,
sick.
I'm sorry, I broke the flow.
That's okay. It is.
Like, wait, you answered the question. That's not relevant. Okay,
Yeah.
my bad.
There's no valuation value for the Aberdeen property listed in this paragraph, correct?
I don't know.
Okay, it's not. So why don't we put back Plans Exhibit 719? There's the supporting spreadsheet for the 2014 Statement of Financial Condition. We can go to row 481, please. 481. Here we see a listing for Trump International Golf Club Scotland. That's your club at Aberdeen. Is that correct?
Yeah, right.
If we look over in column G, we could see the valuation for 213. I'll rephrase the question. In column G, we see the valuation as of June 30, 2013. In column H, we see the valuation as of June 30, 2014. Do you see that, or do you see the dates?
Do I see what?
The dates at the top. G is, I'll direct you to it. Yes. That's
Yes, yes, I do.
right. June 30, 2013. H is June 30, 2014.
Right.
Okay, let's go down and take a look at those valuations, which I believe are down on 43 or 46. No, I was wrong. If we stop here, it's 527. So you can see the valuation as of June 30, 2013. It's $191,165,600 as of June 30, 2014. The valuation is $435,562,426. And this is the part that makes him nuts. That he has the numbers jump so dramatically. That's this where they goes from like 190
from 191 to 435.
Right.
In a year.
In a year. Yeah, that's where they're like, how the hell is that? Like, how is that not fraud that you're committing
It's
here?
like double or more, right?
Right. That's where they basically are freaking out about.
Yeah.
Do you see the difference?
Yes, I do.
You did not build a second golf course in Aberdeen between June 13th and June 2013 and 2014.
I'm building it now.
So you had not done it by June 2014.
No, I didn't. The first one, it was very successful. The second one, and then basically you would have 1,000 acres of land. You have 1,230 some odd acres. It's a lot of land on the ocean. And it was a big development job. And I could do it anytime I want. I just really want to do it. I don't really need to build 2,000 or 1,000 or 500 houses in Aberdeen. I don't want to do it. This is an artistic expression. I think it's the greatest golf course ever built. I believe it is. And we've gotten reviews saying that we are close to that. It's one of the greatest pieces of land I've ever seen. And we have now one, of course, and we've built a clubhouse. We built the roads. We built everything. I'm in no rush. I'm not looking to build a lot of things. I'm doing other things right now, but it's an unbelievable site. We could build more than what you showed in the plan, or less than what you showed in the plan, but I don't want to build anything. I just want to sit with it. It's called an investment.
It's called an investment. So I just want to make sure I heard that last part. You're not planning to build anything as of today?
Well, I'm building it right now.
Apart from the golf course, you're not planning on building any housing developments?
I'm sort of preparing the site because I'm putting up the second course and it's under construction. It'll be done in a year. And then we'll have all of this. We'll have 1,000 acres of land that we can do whatever we want with. But I'm in no hurry to do anything with it. I have enough things to do.
And your statement was, I'm not looking to build a lot of other things right now. Is that correct?
I'm not looking to, I said I'm not looking to go to Scotland and build a big development, but it's got tremendous value.
So we got away from the actual question, which was, I believe that you did not build a second golf course at Aberdeen between June 2013 and June 2014, correct?
Yeah, nor was I supposed to.
And you did not build a new hotel at Aberdeen between June 2013.
Because I didn't want to.
And you did not build any homes at Aberdeen between June 2013 and June 2014, did you?
No, I have a castle that we renovated. But no, I want it just the way it is. And at some point, maybe in a very old age, I'll go and do the most beautiful thing and you've ever seen. But I just don't have, I just don't want it now. It's an unbelievable piece of property.
I'm focused then on where we got the 245 million increase in value from the property from 2013 to 2014. So I would like to go back up to, if we look at it, let's go down to see 489 at the top. I'll represent to you. Well, no, go down a little more. That's it right there. So you'll see the valuation for the club, the golf club. The land allocated to hotel and residential, the remaining value for the golf courses stays about the same. It goes from 76 million in 2013 to 2014. The remainder of the value for 2013 comes from the line item valuation per George Sorial email 9/6/2011, in addition to DJT capital contributions. George Sorial was a lawyer at the Trump Organization. Is that correct?
Yes.
He was not a valuation professional. Is that correct?
No.
Okay. And if we look at what changes in 2014, we can go down to the column starting at 508 that says value of undeveloped land. And you see there that it's listing that says the residential parcels are 83,000 pounds each. The number of homes to build at 2,500, which generates a value of 207 million pounds, which is then converted into dollars. That's the basis for the 245 some odd $1 million increase in value. Is that correct?
I really don't know. But the job could be much bigger than that. Could be much bigger than that too. It's 12,000 acres, more than that.
1,200 acres.
12 zeros, whatever.
Yeah.
It's Trump, so zeros are optional. Fronting the entire width, fronting on the North Sea. It's like one of the easiest in the oil capital of Europe.
I'm asking, was it actually done?
It's a very nice piece of land that everybody said.
This is where he's dancing, and he doesn't have an answer. He's totally dancing because this is where they actually have him. They actually
everybody said could never be zoned, and I got only. Oh God, this is so funny. Sorry, and I not only got it zoned, I got it zoned for much more than anyone ever thought possible.
I'm not going to kid you. This is where he's like, yeah, he totally made that number. I mean, totally made that. Like nothing changed about the property during that year, and it went up in value by more than double. Based like that's kind of funny.
But they bought it. I mean, they believed him. I mean,
and the truth is, they could have looked into it. Also, do you think that a bank was just loaning him hundreds of millions of dollars?
If you tell me your house is $150,000 today, and then tomorrow or next year, tell me it's $500,000. And I believed you today, and then I believe you next year.
Yeah.
Whose fault is that?
Yeah. Yeah.
Whose fault is that? Is that Joe? You're full of crap. Yeah. Well, I might be full of crap because look at all of what everybody.
I agree with you.
Joe, the crap pullers, but here it is. I'm offering it to you for $500,000.
I've spent the last almost 3 hours now screaming about how this disclaimer should be completely operative and have had this case dismissed, and I stand behind that. I'm simply saying
it should be every car. It should be in every car note.
And I think it's humiliating. It's humiliating to that New York justice basically is saying that this trial is allowed to proceed. And this what I'm about to say now doesn't change any of that. I'll simply say that once someone starts with a premise that they're not accepting this disclaimer and they're looking to catch him in something that seems really dicey, out of everything they discussed this entire morning, this is the part which is like he doesn't have an answer for it. He's dancing so hard here because on this one he doesn't have an answer because they should have looked into it and they should have realized that the property value that he's putting on it.
Well, right. I mean, if Trump sold them a bill of goods,
his numbers out of thin air. Yeah,
and they were happy to buy it, and it was all good.
Yeah. Please split those screens. If we look, it says the valuation says there are 2,500 homes.
Yes.
But the statement itself says that it's 950 holiday homes, 500 single-family residences, and 36 golf villas.
More luxurious. Yes.
And I'll represent to you that it comes to 1,486 homes in total with only 500 single-family residences. So the statement of financial condition for 2014 does not accurately disclose the number used in the calculation. Is that correct?
Those homes will sell for a tremendous amount of money. They are on the North Sea. I could also go with a much bigger job if I wanted to. The relationship is very good with Aberdeen. Aberdeen is a very rich place. It's an incredible piece of land. And again, it may be the greatest golf course ever built. And I own Turnberry and I own great ones. The numbers there are not shocking numbers. And this, a very big job. This is a very big job. I just don't want to build it now. You're probably right. I'm doing other things right now.
Mr. Wallace, so what following your lead? If you want to let the witness ramble on, be unresponsive, repeat himself, go ahead. This is finally the judge recognizing I spent all morning completely breaching what any lawyer in New York has ever seen a judge do in the way they handle a witness, in interjecting on behalf of the questioner and striking stuff without even there being any answer, or saying, irrelevant, or other nonsense. But at a certain point, I can't do that for you anymore. So if you're going to I don't want you to let him ramble on. I need you to object so I can actually uphold your objection and strike all this stuff that he starts rambling on about. But if you're not going to object, I can't do it for you anymore. That's what he's saying here. I might normally move to strike, but there are things I would like to preserve for the record in that answer, so I'm reluctantly allowing this to continue. You see, and that's why a judge should never be interjecting. That's exactly why. That's why it's so terrible. It's poor form. It's in my opinion grossly improper for any judge to be objecting on behalf of the questioner, because like over here, Mr. Wallace actually wants these questions to be answered. He wants him to ramble on. Why the heck would a court start trying to control the witness without having any request from the attorney who's cross-examining them? It's insanity.
Well, yeah, I mean, it puts the court in a position the court's not supposed to be in.
Precisely.
Right?
Precisely. It's like they're sitting there as a second attorney.
Right. He should be pushing back against each of the attorneys as the things go along.
Well, as he's saying here, he should be letting them take the lead as to like, okay, objection, move to strike, meaning we don't like that there. And there's no real rules that allow that to go in there. So we want that out. As opposed to the judge saying,
as makes a matter of law,
question, so I'm striking it. That is inappropriate, because sometimes it's beneficial to the questioner to have the guy ramble on. So why is a judge sitting here? Because that opens up for them talking.
Right, because he's on the other side of the fence going rah rah for one team or the other, and that's inappropriate for a judge.
It's not just that it's inappropriate; it actually could be hurting the AG. Meaning it could be harmful to the AG, and that's why a judge should not be doing it. The AG could look the same way Wallace here. What's he saying? He's saying there are things in there that he just said that I didn't really ask him about, but I'd like to preserve for the record. So I'm glad that he's rambling. Well, how can a court know on behalf of the attorney who's asking questions when that attorney is happy about rambling versus not being happy about it? The only way he could know is if the attorney objects and moves to strike. But otherwise, he's jumping into the head of the attorney who's asking the questions, and that is grossly improper for the judge to do.
Of course, totally.
And he's like, that's why I'm following your lead. I just want to note, I'm not really sure it's clear. Maybe this is
the court says that's, I'm sorry, I'll stop, full stop, layperson question.
Yeah.
The court, meaning the judge, says that's why I'm following your lead.
Yeah.
As a layperson, who saw a couple of videos on YouTube about how law works, that seems kind of weird to me. I thought the attorneys follow the judge's lead, or the attorneys push the judge.
Well, he's explaining what he just said earlier. He goes, I'm following your lead that if you want to let him ramble on. He's basically implying I wouldn't be letting him ramble on the way you are, but if you're not going to stop him, I'm going to follow your lead on that element of allowing him to ramble on. Meaning he's basically telling him that everything I was doing until now about interjecting on behalf of you, I'm not going to be doing that going forward. I'm letting you decide whether or not something he should be rambling.
Oh, okay.
That's what he's basically saying.
At least we don't have to worry about the judge doing the judge thing.
Hopefully, yeah. Although I at this point I was already here, and I don't remember him interjecting too much after this. So I just remember that he just continually overruled objections that come up over the next I don't know, 100 pages or so. I just want to note, like I said, I'm not going to finish everything here. What I plan on doing is I'm going to get to the lunch set break, which is probably coming up in like another 10 pages or so. And then I'm going to jump through, and I'm going to excuse you if you can stick around if you want, or you can go. And I'm going to explain my issues with decision, and I'm going to figure out what I'll do with the afternoon.
Somebody has to tuck my wife in.
If you need to go now, by all means, go ahead, brother.
Hey, man, thank you.
Thank you. Thank you for kicking around here.
Thanks for the hang. I'm not a Trump impersonator.
You did great. And just having
I'm not a very good reader, but I'm having fun with my friend Joe.
We had a great time. I'm really glad you popped in here.
And for crying out loud, kudos to you for reading not only 3 parts, but one of them in a very high tone of voice, which
God
kind of got me a little bit aroused.
Tough to do.
My poor wife.
All right.
Hey, man, it was a good hang. It was a good time.
You too,
I'm
my
sorry
brother.
I can't stay longer.
Later. No, you were great. Thank you
me
so much
at
for
all.
staying as long as you stayed. You thought you were going to be here 2 hours and you stayed 3. So thank you, brother. Take care.
All the best. And thanks, everybody, for being cool.
All right. Later, brother.
Bye now.
All right. Where were we? So I'm going to move this over like this now. All right. I just want to note, I'm not really sure it's clear. Maybe this is the subject of the ambiguity. I mean, I think his answer is a brilliant answer. I just don't know if he's answering the question because he's confused as to whether or not we're talking about the statement of financial condition or the backup data, which he's testified. I think Mr. Wallace has already admitted the witness has never seen before the backup data. So I'm not sure what he's answering, whether he's talking about the backup data or he's talking about the statement of financial condition, or if the question is both. I don't think my question was answered, so I'm going to re-ask it, but I'm happy to have, if you could clear it up, that's fine. I just think it's not even in the record. I'm just asking that his prior statement remain on the record, even though it's non-responsive. Mr. Trump, my question is more directed. It's simply that the number of houses used in the calculation for 2014 did not actually match the number of homes disclosed in the statement. Is that correct? I don't know, but it could very well be. It's sort of like a painting. You could do pretty much what you want to do. The land is there. You could do what you want to do. So you could do either one of them actually. As of 2012, you had actually made a determination that you would not be developing the Aberdeen property because of Scottish plans to build a wind farm offshore. Is that correct? Well, I was not happy because they've fought long and hard to build windmills. I think 9 of them out in the ocean, out in the sea, and they built them. Okay, they being Scotland. And because of those windmills, you decided in 2012 that you were not going to be doing further development of the Aberdeen property. I told them, I don't know if it has an impact or not. I'm not a windmill person. I think I'm being proven to be right. Did you testify about your unwillingness to develop the Aberdeen property for a subcommittee of the Scottish Parliament in 2012? Yes, I did. And do you believe that, I'll see if I can skip ahead and just ask, would it sound correct to you that Mr. Weisselberg submitted a statement to the UK regulators in September 2014 saying that the Trump organization did not intend to develop the Aberdeen property any further based on the wind farms? We had a big fight over the wind farms, but they were put in years ago. They've been there for many years now. They'll probably come down like all the other wind farms are coming down. And I've been asked whether or not they have an impact. They're miles out in the ocean. They're not on the property. They're miles out. And most people tell me no. Almost everybody tells me no. I don't know if that's true. He's so good. They're miles out. Most people tell me no. Almost everybody tells me no. I don't know if that's true. But regardless, we have the right to build a very big project if I want to build it. That was in 2014 when we were fighting the windmills. Yes. As of today, November 6th, 2023, you haven't built any homes at Aberdeen. Is that correct? It's just a beautiful piece of property sitting there waiting for homes to be built. It'll be very successful. I just don't, there's nothing wrong with sitting with property and waiting if you have the money to play that game. And I do have a lot of money, a lot more money than you thought, I guess. At some point, that will be developed into a magnificent job. I just don't want to do it now. Mr. Trump, apart from the Seven Springs valuation we discussed and your apartment, do you stand by all the valuations in this statement of financial condition for 2014? I haven't looked at it in years. Do you have any reason? So you might not agree with the valuation in here anymore, is what you're saying? I think I've been proven to be right. Because if you take those valuations and bring them up in 2021, a couple of years ago, they are much higher than they were in that statement. But the valuations were the estimated current value as of June 30, 2014. Isn't that correct? Yeah. But if you carry that forward to 2021, all of those valuations were low. Meaning the properties are now worth more today, November 2023, than they were much more, than they were in June of 2014. Okay, apart from the Seven Springs valuation we discussed and the triplex apartment, are you aware of any other apartments properties on the statement of financial condition between 2011 and 2017 that were overstated? Not that would have, I don't know of any, but not that would have a material effect because I'm worth billions of dollars more than the financial statements. Oh God, this I think is where I started laughing, and I there was one point here, and it was somewhere around here that I just started guffawing like that, like started laughing and said, "How does anybody not love this guy?" When I was watching this in court, because I'm worth billions of dollars more than the financial statements. The financial statements are just the opposite of what your attorney general thought that and they're having big problem with it. I'm worth billions of dollars more. So anything that would be a little bit off would be non-material. Are you aware of any non-material items that were overstated in the statement of financial condition between 11 and 17? I haven't looked. Do you still approve of the work that Mr. McConney and Mr. Weisselberg did preparing the statement of financial condition between 2011 and 2017? Well, again, we have a disclaimer clause that tells you we are doing the work. It's not in accordance with your normal, if you're going to do some kind of big certified statement, you're not doing appraisals and everything else. We have very important clause called a disclaimer clause, and it's a 100% disclaim. And some people call it a worthless statement clause. They call it lots of different things. And as you will be hearing in testimony, they always hold up in court, except maybe in this court. They always hold up in court, always. It's a disclaimer. It says very strongly, do your own diligence. Do your own work. Do your own study. Don't take anything from the statement for granted. You could look at the statement, but you must do your own analysis and due diligence. Do you still approve of the work that Mr. McConney, Mr. Weisberg did in preparing the statements of financial condition between 2011 and 2017? As far as I know, I do. You haven't shown me anything that would change my mind. Same thing true of the statements that came out between 2017 and 2021. You stand by that? I was assured of 2021, but I was president, and I was not involved in any way by that. I was doing other things. You were not aware of anything that was done that you disagree with, but you're still not familiar with the statements? Probably the statements would be, again, if there was a mistake, it was non-material. But if it was material, and I don't see that, and we did make some changes where they found out there were mistakes, we have a disclaimer clause that says do your own diligence, due diligence. Don't, under any circumstances, count on anything here because it was done. They're done quickly. They're done. It says, I think, it says done in accordance with the owner's projections and the Trump organization's projections and everything else. So one of the reasons I never got too involved with these statements was that clause is on page 1, as you know better than anybody. It's also throughout the statement. When you read the statement, everything is disclaimed. They say, go out and do your own work. Don't believe it. Get your own appraisers. Get your own accountants. Do everything. And that's why we shouldn't be having a case here, because we have a disclaimer clause that every court in this country holds up except for this particular judge. Get him! Get him! Get him! Everything he's saying is so true. 100% true. Spot on accurate. Everything he says here, spot on accurate. Can I ask, Danny, is your particular position that the statements of financial condition are, in fact, worthless? No, I don't think they're worthless, but I don't think they're worthless at all. But I think that frankly, with the disclaimer clause, if there's any mistake, the disclaimer clause covers it. And because they didn't devote their entire life to this. And again, most developers don't do this. They just write the name of the building and the address and the address of the building. They put some number that they think it's worth. They don't have anything like this. What I've done is far more, and it's also far more conservative. You never mention the fact that we have $400 million cash in these things. People don't know how good a company I built. You know why? Because people like you go around and try and demean me and try to hurt me. Mr. Trump, probably for political reasons. In her case, and he was pointing at Letitia, ooh, definitely for political reasons. And I think it's hurting her. There's a lot in there I wanted to keep, Your Honor, so I'm not going to move to strike that. Such a loser. He just trashed your boss. He just trashed your boss as being a political hack. And you're like, I'm going to keep that in there. Not move to strike. I just want to go back and clarify one thing in your last answer. You said they did not devote their entire life to them. Who is they referred to? That would be Jeff and Alan. They had other things to do. Does that mean that Jeff and Alan were not being, that's McConney and Weisselberg, the two accountants who were handling this. Does that mean that Jeff and Alan were not being careful when they prepared your statement? No, I think they were being careful. But again, the disclaimer clause says if there's a mistake, if there's something, it says don't rely. It's called a non-reliance clause also. I mean, it's a very standard thing, and it's allowed in every court in the United States. It's non-reliance. You stated that. I know I'm trying to make you understand it. It's non-reliance clauses, and every court in the United States has upheld them. And every legal scholar that I've read about this case has said, what's going on here? How can a thing like this be going on? It's disgraceful. And in addition to that, I'm worth more than the numbers in the statements. That answer I will move to strike, Your Honor, as repetitive, non-responsive. He's already made that point in the record. I'm not sure there's any basis to strike, a valid basis to strike it. It's an answer. Mr. Wallace is satisfied with the answers. He's calling for these narratives. He's getting answers to the questions. And this goes to the very heart of what we're here about, which is intent. I mean, if intent is subjective, and if this witness's intent is as stated here, I don't see how anyone could ever prove intent under these circumstances. It's a brilliant answer to the question. So Mr. Wallace can't pick and choose which narratives he likes and which narratives he doesn't. We can come back here in 2 or 3 weeks and go through the same charade and ask the same questions, get it out. But as I said, it's far more effective to allow the witness to explain his position, explain to the court his view, what he intended, how he intended it, what was happening, and how he views the statements. The response is even longer than the statement I asked to strike. So at this point, let's leave it in then. Such a cuck. I don't want to have an argument with Mr. Keiss, so I'm just going to agree to leave it in, even though I don't really like a judge who's willing to bend over backwards to help me. I'm still afraid to try opposing Mr. Keiss in argumentation. Leave it in. There's no jury. Doesn't matter. I'm not listening anyway. Oh, did I say that out loud? Was that out loud? I'm not listening to anything that helps him anyway. I'm doing my best here. I'm doing my best. Mr. Trump, I think you said this in the course of your answers. Let me try to just clarify this. You do not agree with the position that the Office of the Attorney General, that the values of the statement of financial condition are overstated. Is that correct? I think she's a political hack. That's not the question. And I think that's not the question. Use this case to try to become governor, and she's successfully used it to become attorney general. And I think she's a political hack, and this is a disgrace. This is a case like this is going on, and all you have to do is read the legal scholars and papers. He just he pulled the cord, and Wallace is like, no. He's gonna answer this question now. Oh my gosh, what was the question? You don't agree with the position of the Office of Attorney General that the value statements are overstated. Oh, yeah. Yeah, you open this door here. You open that door. He's like, no, give me my question back. You open that door for Trump, and Trump's going to sit here bashing his boss. All you have to do is read the legal scholars and the papers, and you'll see exactly what I'm saying. A lot of them don't even know how valuable the properties were. You never said Trump has $300 and $400 million cash, and now more than that. This is a political witch hunt, and I think she should be ashamed of herself. You do not agree with the position of the Office Attorney General that the values of the statement of financial condition are overstated. Is that correct? Please bash my boss some more. He's so bad at this. He's an attorney, the assistant attorney general. Why are you so bad at this, Wallace? You know what he's going to... You just asked the exact same question. Oh, gosh. So bad. The overall value is billions of dollars more than in these statements. So that when a bank gets them, the bank is seeing a conservative statement, not a... She tried to make you believe, even yesterday, she's out there saying, oh, fraud, fraud. This is the opposite. Fraud. The fraud is her. When she says Mar-a-Lago, she said it's worth $25 million. He said it's worth $18 million. Points to the judge. He said it's worth $18 million. $18 million. She said it's $25 million. She convinced him that it's worth $18 million and it's worth $1 billion or something like that. Yes or no? It's a disgrace. It's a disgrace. Yes or no? Do you agree with the position of the Office Attorney General that the values of the statement of financial condition are overstated? Asked and answered. It has not. No, it has not been asked and answered. No, because now before it's Attorney General, now it's the... I don't even know what the statement of finance... Of course it was asked and answered. He actually did the... It's been asked. He hasn't answered. Yeah, I'm not screaming. What? Hold our respect, Your Honor. I don't appreciate when people scream. The overall value is billions more was the answer. That's his answer. You can read it in the record. It's a yes or no question. Just a yes and no, Mr. Trump. Do you agree with the statement? The position of the Office of the Attorney General is the values are overstated. The financial statements are very conservative. The overall number of value is much higher than the number in the financial statements. In addition to that, you have 100% disclaimer clause that goes on for a page and a half. No, no, no. We're not going to hear about the disclaimer clause. If you want to know, it's very important about the disclaimer clause, read my opinion again, or for the first time, perhaps. Well, you're wrong on the opinion. It's sad that Trump has never practiced law, and he's more accurate on the law than this judge is. At least in my personal opinion. Mr. Trump, let's go to that then. Mr. Trump, you do not agree with the determination of the court in its summary judgment decision that the statements of financial condition were misleading. Is that correct? He ruled against me without knowing anything about me. He ruled against me and said I was a fraud before he knew anything about me. Nothing about me. And then he said in his statement that Mar-a-Lago is worth $18 million and it's worth 50 times to 100 times more than that. And everybody knows it. And everybody's watching this case. He called me a fraud, and he didn't know anything about me. You did not. So I think the essence of your answer is there. But I'd like to get it as a yes or no. Such a stupid thing. This is such a stupid thing for him to be hammering on. Of course he disagrees. Who cares? Who cares? Why do you keep going at this, Wallace? It's so dumb. It's such bad lawyering. It's hilariously bad. You did not. So I think the essence of your answer is there, but I'd like to get it in as yes, no. So you did not agree with the determination of this court in its summary judgment decision that the statement of financial condition were misleading. Is that correct? I think it's fraudulent, the decision. I think it's fraudulent. The fraud is on the court, not on me. When you rule that Mar-a-Lago is worth $18 million, I can give you a quarter of a tennis court would be worth that. 1 quarter of a tennis court, $18 million. When you rule that Mar-a-Lago is worth $18 million, then she rules it's worth $25 million. Either people are very stupid or there's a fraud. Get him. The fraud is on behalf of the court, because when the court does that and they say, I didn't value my property correct, think of it. 18 million, he said. And then he says, I'm a fraud because I didn't value my property correctly. He's the one that didn't value the property correctly. Mr. Trump, and how do you do that? How do you rule against somebody and call them a fraud as the president of the United States, who did a great job? I did a great job as president of the United States. Only Trump could be sitting here facing crazy civil penalties, unprecedented civil unprecedented civil penalties, and come out here stumping to New York, an exclusively New York audience about what a great job he did as president. This is just so Trump. It's like so amazing. Oh my gosh, so amazing. By the way, if you're over here on Trump Trial channel and you could like and subscribe, muchas gracias to you. Muchas gracias. Oh, sí, señor. Oh, muchas gracias. Por favor, please hit like and subscribe. If you could, please, señor, hit like and subscribe. Whew. Mr. Trump, and how do you do that? How do you rule against somebody calling fraud as president of the United States, who did a great job? All you have to do is look at the president today. What's he doing? What he's doing? How do you call a man a fraud when you have a property that's 50 to 100 times more valuable? It's a terrible thing he did. You knew nothing about me. You believe this political hack back there, and that's unfortunate. Are you done? Done. Okay, I'll take you up on one of the invitations. You're talking about the 18 million valuation versus the higher valuation in Mar-a-Lago. Which one are you paying taxes on down in Florida? Which one? What? Are you paying taxes on an $18 million valuation in Mar-a-Lago or $1.5 billion? You know that assessments are totally different from the valuation of a property. By the way, this is totally true. Totally true. What they value a property, what the real estate taxes values a property at has nothing to do with it. This is such an asinine question. He thinks, aha, gotcha. You see, you're paying taxes if it's worth only 18 million. That's a joke. And anyone who's been in real estate for more than 12 seconds knows that. And the AG should know that. This is the AG is either being completely fraudulent or displaying utter incompetence. There's no other explanation for raising what he pays on, with the assessment that he pays taxes based on. You know that the assessments are totally different from the valuation of property. An assessment, as an example, in New York, you sell a building was recently sold for $1 billion. It's assessed for a tiny fraction of that. Same thing in Florida. Same thing in other places. Other places have full assessments. Whatever you pay, that's what the assessment is. That's not the way Palm Beach, Florida. It's not the way in New York. And it's not that way in most cases. If it was that way, it would make a difference that the property has been appraised. Sure. At 18 million in Florida, that would be a much different thing. Mr. Trump, I'd like to go back to the statement of financial condition quickly. If you could put Exhibit 730 back up. You go to page 2. This is a paragraph we looked at before. It's the second paragraph which states Donald J. Trump is responsible for the preparation and fair presentation of financial statements. I'd like to focus on the second half of the sentence, which says Donald J. Trump is responsible for designing, implementing, maintaining internal control relevant to the preparation and fair presentation of the financial statement, basically saying he's on the hook. I'll ask you an open-ended question here and then complain when you give me a complete answer. Sorry. What did you do to meet your responsibility for designing, implementing, and maintaining internal control relevant to the preparation and fair presentation of the financial statement? I gave 2 people total authority to work with a very expensive accounting firm, very high-priced accounting firm who charged me a lot of money for this, a lot of money. And they worked with the accounting firm, and they came up with the statement. I could have done this statement like many other developments where I just write down the building and put a value. I didn't choose to do it that way. I told them to work with the accounting firm and give them what they need, and that's what they did. And so the 2 people you're referring to, once again, that's Mr. McConney and Mr. Weisselberg, correct? Correct. And you did them, and so you direct them to prepare the statements in accordance with GAAP. Is that correct? I don't know what it was. I said, prepare the statements so that the accounting firm is happy. So they gave us a statement. The question is what steps you took I told you, to design, implement, maintain internal control relevant to the fair presentation of the financial statement. I just told you. Okay. Anything else you did in connection with this obligation? No. But if you look at the paragraphs, and I don't know if Your Honor, if I could do this, but if I have it in my pocket, if you look at the paragraphs that follow that, This is a total exculpation. And if you would like to have it, I would read it if you'd like, or I don't know what the procedure is, but I've taken this right out of this, and it's very simple. It says exactly how important that clause is. And it's been written about by legal scholars. Between Mazars and the Trump organization. Oh, let's continue on the next page. I don't know. Okay. Between Mazars and the Trump organization, who is responsible for the fair presentation of the statements of financial condition? I think they work together. Who was responsible? They get paid a lot of money too. Who was responsible for making sure the statements were compliant with GAAP? I don't know. I assume. I don't know. Were they supposed to be compliant to GAAP? Because I'm not sure that that's true, because GAAP is defined a certain way. I'm not sure that's true. But certainly the accounting firm, which got paid millions of dollars to do this work, they had to do something. Mr. Trump, they got paid a lot of money to do this work. Do you have an understanding of what responsibilities, if any, the Trump organization had in connection with the preparation of the 2014 Statement of Financial Condition? Which I would have objected here. I would have screamed, objection calls for a legal conclusion. I would have objected here. This is a question that's calling for a legal conclusion. Well, I think I've answered this question about 5 times. What is the answer? I told 2 top people to work with the accounting firm, give them whatever they needed, anything they needed, give them so they can come up with a statement. And if the accounting firm was unhappy, they would go back and they would say, we need this, we need that. And they were very insistent on that, But they came up with statements in each of those years, so obviously they were satisfied with that. Could we put up a copy of Plaintiff's Exhibit 717? I think it's already in evidence. Mr. Trump, I've been handed a document that has been marked as Plaintiff's Exhibit 717. This is the engagement letter for the preparation of your June 30, 2014 Statement of Financial Condition. I'll just direct your attention to the 3rd page of this document, which has a heading, Management Responsibilities, and lists A through F, a series of responsibilities. Do you have an understanding that the responsibilities listed here were for the Trump organization to undertake in the preparation of the Statement of Financial Conditions? I don't remember this, but it looks like that, yes. So to your understanding, the Trump organization was responsible for the preparation and fair presentation of financial statements in accordance with accounting principles generally accepted in the United States of America, other than previously noted. Is that correct? Yes, but together with working with the accounting firm, the very highly paid accounting firm. The next item states that management is responsible for designing, implementing, and maintaining internal controls relevant to the preparation and fair presentation of the financial statements. That was a Trump organization responsibility, correct? Sure. Item C, presenting and detecting fraud. That was a Trump organization responsibility. Sure. Is that correct? I would imagine that they all had to work on it. This was the accounting firm for the company. And I would imagine they all worked on that. You do audits. You do all of these things that you would normally do. And hopefully, if something is wrong, you catch it. Who within the Trump organization was responsible for presenting and detecting fraud? Everybody. Item D. Who within the Trump organization was responsible for identifying and ensuring the company complies with the laws and regulations applicable to its activities? I would say, sort of anybody who sees anything wrong, they should report it. Anybody. Is there a formal system for reporting anything wrong as you described it within the Trump organization? Not formal, but I say to anybody sees anything going on that's not appropriate, come see me directly. I don't care who you are. Has anyone ever come see you directly about these? Yeah, people tell me things. Yeah. What instances do you recall? Things going on and I got the problem solved when I hear it. Now I'm asking if you remember any specific instances of someone bringing improper activity to your attention. Over the years? Yeah, sure. Our apartments that are rented that they say are vacant. Somebody's getting money. Other things, I hear things. Sounds like a big deal, but it goes on. Apartment's empty. They put it down as empty, but somebody's getting money for it. And generally it's the person who runs the building or the management person, or over the years, that kind of thing happens. And I take care of the situation when it happens, but I want everybody to look. I tell everybody, if you see something, if you see anything, come to see management or come see me directly. I don't want that going on. And that would have been the case up until he became president in 2017. That's correct. That no longer happens from 2017 to president. Is that correct? Well, president is different than it was, prior to when I was president. Right now, unless you know something I don't know, I'm not president. Unless you know something I don't know, I'm not president. No, I'm just asking. People still come to you with problems that you identify. Yeah. What do you remember? I don't think they come. I'm not sure that they come. I haven't remembered a thing like right now. So we're a little new to the game because I haven't been doing this. I'm back a little bit in the real estate business, right? If you look at item E on this chart, it says selection and application of accounting principles. Do you know who within the Trump organization was responsible for the selection and application of accounting principles? No, I would assume that the accounting firm would recommend something and we would accept it. I'm just pointing out this under the heading management responsibilities. Right, but I would assume. Can I finish my question? Yeah. Do you know if anyone at the Trump organization was responsible for this on the Trump organization side? Again, I would assume that Mazars would come and recommend something and we would accept that procedure. Item F is making all financial records and related information available to us for the accuracy and completeness of that information. Who within the Trump organization was responsible for meeting that responsibility? That would be the staff in the back. That would be Jeff Allen and the staff. I would love to read this, Your Honor, if I could. Am I allowed to do that? No, not at this point. I'm shocked. Okay, we can take that down. Mr. Trump, I'd like to talk a little bit about your building at 40 Wall Street. Yeah. Have you ever inflated the operating income of 40 Wall Street in order to increase the reported valuation? Not that I know of. Can we take a quick look at Plaintiff's Exhibit 719? Sorry, we need the native version. I apologize. And we could do it for 118. This is the entry for 40 Wall Street. And if we scroll down to rows 137 or so, there's a valuation for 2014, and it states NOI stabilized based on cash flow prepared July 2014, including pending leases, green ivy, and vacant space, and lists an NOI of $23,873,545. Do you know if that's an accurate reflection of the NOI? I don't. It's a long time ago, but I don't. Mr. Trump, I'm handing you a document that has been pre-marked. It's a copy of an article from Forbes magazine dated September 21, 2022. Now, I would just like to direct your attention to the bottom of page 11 of the article. This part is great. This part's great. this part coming up here, this made me laugh. There's a headline that states, a couple months after securing the loan, Donald Trump was feeling good, sitting at his desk in Trump Tower, speaking openly to Forbes about his years-long quest to vault himself higher on the list of America's richest people. An audio recording of that conversation, which took place on September 21, 2015, makes it clear that Trump was not only involved in the effort to misinform the world about the value of his assets, he was willing to take the ruse further than anyone else and even admit his motivation for doing so. It was good for financing, he said. I'll stop you there. Do you recall speaking to Forbes in September 21, 2015? No. And who would say that? I'm not saying that, Forbes. They're owned by China. Now, they just said it. They just sold it to Russia, I read yesterday. Did I tell you? No, these Forbes are owned by China. It's the most Trumpiest trial of the year. I'm not saying that Forbes, they're owned by China. Now they just sold it to Russia, I read yesterday. Did you tell Forbes ever that a high net worth is good for financing? I mean, it's something that I would say a high net worth, good for some types of financing, not for buildings, not for specific deals necessarily, but I guess having a high net worth makes it would be good. Do you want me to say, oh, let's have a low net worth? Give me a low net worth and let's get financing. Do you want me to say that? Give me a low net worth and let's get financing. No, having a solid record, having a good net worth is a positive thing. I can't say it's not. If we look down the next paragraph, it states, even though he had just reworked his mortgage at 40 Wall Street, Trump couldn't resist another chance to boast about it. It's a 78-story building, Trump said, even though his firm had previously marketed it as a 72-story building, and it's actually just 63 stories according to documents filed with the city. Again, filed with the city that the bank could never find them. It's going to throw off. Would you say 50 million maybe this year? He asked, turning to Alan Weissenberg. 50 million at least. Trump concluded fast, and the CFO can get out the words, yeah, by the end of the year. We can stop there. Do you know whether or not it was true that 40 Wall Street in September 2015 would throw off 50 million by the end of that year? I don't know, but I have very little respect for Forbes. Very little respect for Forbes. So what I say to them, I deal with them very quickly. and I don't even deal with them. I haven't dealt with them in years. So do you believe they were misquoted? I think they're out of business, aren't they? I think they're out of business, aren't they? Do you believe you were misquoting this statement? I don't know. I don't know what I said. You're giving me this information. If you have the statement, let me see it. I'm going to move ahead. This is so hilarious. This is killing me. It's killing me. I'm going to move ahead. I don't think too much about what I say to Forbes. I don't think too much about what I say to Forbes. We'll move ahead to page 13. The lower paragraph will start there. It says, a Forbes reporter noted. It's like this idiot keeps citing a Forbes case, like as if this is evidence of anything. It's so stupid. You told a Forbes reporter. Unless he told a Forbes reporter that he's committing fraud, doesn't mean anything. Any representation makes to fraud to Forbes is useless. It's so stupid. To anyone who's got half a brain and isn't completely filled with TDS, I guess he's preaching to the choir here. It says the Forbes reporter noted that the building was 1.2 million square feet, rounding up from its actual square footage of 1,165,207. It's actually 1.3, Trump said. By the way, it is 1.3 to be honest with you. The same reporter then said Forbes was estimating his net operating income at $24 million, the inflated figure that Jeff apparently McConney had shared the previous year. Where did you get that from? We're going to make $64 million net after debt service this year, at least, Trump declared. Do you recall telling Forbes that 40 Wall Street was going to make $64 million in 2015 net after debt service? No, I don't. When was this? 2015. It's a long time ago. I don't know. I believe Forbes published an audio clip with the article of this interview. I'm just going to ask if we can just play that now. Your Honor, can anyone actually hear that? It seems they play the clip. It seems relatively undecipherable. I could not make out what was being said. Let me skip using the audio. I don't know if we can get any higher. Can we? I'll just ask them generally. I know it was hard to decipher what was on the recording. Does it refresh your recollection that you may have spoken to Forbes in 2015? Nope. You think he's stupid enough to say, oh, yeah, now I remember? No. Do you believe it would have been accurate to say that 40 Wall Street was going to make $64 million in 2015 net after debt service? I don't know. I don't know. You're putting me back a long time ago, long past statute of limitations. All right, I don't know. We're going to hand you a copy of a document that's already in evidence. It's Plaintiff's Exhibit 652. It's a very small print, so it's going to be easier to see it up on the screen. If we can go to page 2 of this document, if we can go zoom in on the far right column, it says 40 Wall Street income and expense statement, cash basis, 12-month period ended March 31, 2015. If you look at that on the bottom of the pullout here, it says total receipts for the building are $29,906,000. Do you know if there was an accurate if that was an accurate reflection of the total receipts of the 12-month period of 40 Wall Street as of March 31, 2015? It's like they're freaking out about what he told Forbes that it's worth 50. It's bringing in 50 or 60 or 63 million net when it was really only bringing in a little under 30. How is that relevant to this stupid thing? No one knows. I don't know. I have never seen that before. If we scroll down to the bottom of the column, actually go to the bottom of the last page, please. Apparently, they're trying to sanction him for lying in an interview to Forbes. This is really relevant in 2011. If we look under the 2015 March 31 under net debt service and capital disbursements, it states the excess cash flow deficit from 40 Wall Street was negative $8,736,924. You know, 40 Wall Street in fact ran a deficit of more than $8.7 million for the 12-month period and then March 31, 2015. Well, we spent millions of dollars based on that. We spent millions of dollars on building improvements. We were fixing the building. I spent a lot of money inside the building, my own cash, to improve the building. We rebuilt the lobbies. We rebuilt the elevators. We spent a lot of money, and actually even more than that, I think. But the building has been a successful building. The building improvements number, we can see there that under capital disbursements is listed as $8.2 million. Is that what you're referring to? Yeah, but we're doing a lot of work. We're doing the elevators and lobbies, doing a lot of work. And the building needed a lot of work. I take it you don't know whether or not it is accurate that on March 31, 2015, 40 Wall Street had run a deficit of $8.7 million. After spending millions of dollars on fixing the building, yeah, it's possible. but then you make it up in later years. You lease to good tenants, and they pay you a lot of rent because they like what you've done. So he's like, that year was a losing year. What the hell is that? How is this relevant? So stupid. Your Honor, I'm going to pass the witness a copy of the documents ready and evidence as plaintiff's exhibit 636. Mr. Trump, this is an email from Donna Kidder to Jack Weiselberg and Alan Weiselberg with an attachment entitled 40 Wall Street 2012 and 2014 cash flows. It'll be easy to see up on the screen. Again, it has very small print. Can we go to page 3 of 5? At the top, it says 40 Wall Street LLC cash flow, year ending December 31, 2014. At the bottom of the section, it states cash flow negative $9,904,289. Do you know if 40 Wall Street, in fact, ran a deficit of more than $9.9 million for the year ending December 31, 2014? That's a very small number. And it doesn't include all the money that was spent in fixing the building, bringing it back to good health. It doesn't show vacancies and things that are leased up. The building is now actually, I think it's pretty close to being fully leased, but it doesn't show vacancy. It doesn't show all the money spent on construction. Am I understanding then? I'm sorry to interrupt you. I'm understanding that this number could be correct, but you think there are other expenses that aren't included in here? We spent a lot of money in fixing the building up, and the building is a very good building. But this has nothing to do. I mean, you can show this de minimis stuff or non-material stuff. This has nothing to do with values. The value of 40 Wall Street is, hundreds of millions of dollars more than what she says it is. She doesn't know what 40 Wall Street. She doesn't even know where 40 Wall Street is. She doesn't even know. I'm talking about Letitia James here. She's like, it's much more than she says it is. She doesn't even know where 40 Wall Street is, and the value is hundreds of millions. If I was going to sell that building because this was a lawsuit that started off with the value, now let's get into rent roll of one building. Big deal. This is all non-material stuff. If we're fixing up a building and spending money on new elevators, new escalators, new all of the things we have in the building, it's going to do very well in the future. You have to do this stuff. Mr. Trump, are you familiar with what technique Mr. Weisberg, Mr. Conner used to value 40 Wall Street for the 2014 statement of financial condition? No. The value of the building I'm familiar with because I would say that building, I could look at buildings and tell you what they're worth. I'd like to move on to page 4 of this document, which lists 40 Wall Street LLC cash flow year end of December 31, 2013. We go to the bottom of the year entry. We see cash flow negative $317,370. $7 million. I think you misspoke. 7 million. I'll restate what it says, which is negative 7,317,370. Mr. Trump, do you know if 40 Wall Street in fact ran a deficit of more than 7.3 million for the year ending December 31 and 2013? I don't know, but it doesn't affect the value of the building. The building is the building. If a developer comes along, they're going to know that you have to spend money to make money with a building, and they're going to know they will either fix it and see what they're doing it. It doesn't affect the value of a building. You're talking about small money. It's not material. And this was a lawsuit based on values. And then when they looked at my statement, when they looked at the cash, they said, oh, we're going to have to go a different way. How about disgorgement? Let's take all his properties away like they do in communist China. Now he's complaining. Now he's going off about this whole lawsuit. He's like, they want to take away my properties from me. Let's take away all of his properties away like they do in communist China. Let's take all of his properties away because, except you have one problem. I have very little debt and I have a lot of cash and I have assets that are much better than you thought. So this was a little bit of a problem. But in this city today and in this country today, maybe a certain judge would do that. Mr. Trump, I promise we'll get through this particular document much more quickly if you can stop at I don't know. And your repeating statements you have made before, I don't know. So I'm familiar with your position. If we can go to page 5 of this document, please. It's the 40 Wall Street LLC cash flow year ending December 31, 2012. We go to the bottom, it lists cash flow, negative $20,990,000. Do you know if 40 Wall Street, in fact, ran a deficit of more than $20.9 million for the year ending December 31, 2012? It could have been for the 1 year it did. It could very well have been, but it makes a lot of money. And it makes a lot of money now. It depends. You have extraordinary expenses during certain periods of time with the building. You have to redo things. But I can just tell you, it makes 40 Wall Street obviously makes a lot of money. And by the way, the money we borrowed is all current or paid off. No bank lost money. With all this stuff, not one bank lost money. Not one insurance company lost money. And by the way, the insurance company that you say lost, they're still my insurance company. It's one of the biggest, most prestigious companies in the world. They don't even know what you're talking about. Mr. Trump, do you recall making misrepresentations about the appraised value of 40 Wall Street? No. Mr. Trump, you're being handed a document that has been marked as Plaintiff's Exhibit 3341. At the top of this is an email chain between Donald Trump Jr., Amanda Miller, Rona Graff, and Jeffrey Lichtenberg. If we can go down to the bottom email in this thread, actually, we'll go put it on the screen so it's easier to follow. There's an email from somebody named Cusisto from the Wall Street Journal to a series of email addresses, including dtrump@trump.org, Rona Graff, DJT Jr., TrumpOrg.com, Amanda Miller, Selma Langer. Before we get into the substance of the document, I just want to first ask, do you know if the email address dtrump@trump.org was ever an actual email address in use? I don't know, no. Do you ever use an email address of dtrump@trumporg.com? Might be, but not that I know of. I want to see what that lunch break is because I feel like I've been going here for a while, a little bit longer than I thought I was. It's on 15:35. I remember there being a lunch break. Am I wrong? Oh, no, maybe I'm wrong. Oh, there you go. There's another 6 pages, another 5 pages. You can do that. You can finish up to lunch break. Go to the top. It says, thank you both for chatting with me about 40 Wall Street. We're planning on running a story tomorrow, so I want to make sure I sent over a few facts. Do you recall whether or not you and Donald Trump Jr. spoke to the Wall Street Journal in or around January of 2012? No, I don't. If you look down under the headline value, item 3 says, the quote, the building is one of the Trump Organization's most significant commercial holdings in Manhattan. It's now valued at $600 million, according to a recent appraisal. Do you know who made the representation to the Wall Street Journal that 40 Wall Street had been valued at $600 million, according to recent appraisal? The year is what year? 2012. 2012? Yes. No, I mean, it's probably around that number. It's not that far off. I don't know. I don't know if anybody has an appraisal, but I know the number is not very far off number. If anything, it could be worth more. I'm asking about the existence of an appraisal. Do you know if there was, in fact, an appraisal at the Trump Organization valuing the 40 Wall Street at $600 million as of January 2012? So you're saying 12 years ago? Do I know whether or not there's an appraisal sitting around someplace for the building? It's such a stupid question. I'm asking if you're aware. Yes, I'm not aware. I'll represent to you that we have not received an appraisal from the Trump Organization Discovery valuing the building at $600 million as of June 2012. Mr. Trump, are you the one? Is Mr. Wallace testifying now? I said I'm representing him what we got in Discovery. Is that part of the question, though? I think you can't just sort of represent. That's fine. Mr. Trump, were you the person who told the reporter at the I'll strike that question, start over? That's fine. Mr. Trump, were you the person who told the reporter at the I'll strike that question, start over? Mr. Trump, it's withdrawn. Withdrawn. I apologize, Your Honor. Are you the one who told the reporter at the Wall Street Journal that there's $600 million recent appraisal for 40 Wall Street? Objection asked and answered. I don't know of any such appraisal. Overruled. We're talking 12 years ago. I don't know. If we look at the top of this email chain, there's an email from Donald Trump Jr. It says, okay, great. There shouldn't be much additional. I don't know where she got the 35 number in renovations, but DJT told her the 600, so he'll be happy if that gets printed. Are you the DJT that is being referenced here? Yes. Does that this refresh recollection that whether or not you told a reporter that there had been a $600 million appraisal for 40 Wall Street in January 2012? Who cares what he tells a reporter? How is that relevant as to defrauding a bank? This is so stupid. This is so asinine. This is so irrelevant. It's so irrelevant. No, but I think the building would be worth about that. I don't think $600 million for that very, very large building is a lot of money. 5-minute warning. Your Honor, I asked the plaintiff's Exhibit 3341 be entered into evidence. Granted. Objection, statute of limitations, and relevance. I'm not sure what the relevance is of a news article. It doesn't have anything to do with the SOFCs. Overruled on both grounds. Why? So, Mr. Trump, why did you have the statement of financial condition prepared? When? Let's say in this period, the period of 2011 to 2017, why was the statement of financial condition being prepared by the Trump Organization? I don't know. I think in one form or another, maybe not officially, we had statements a financial condition. Maybe before that, I don't know. I can't answer that question. We're doing a statement of financial condition. You said you were spending a lot of money to have these men made. Why were you spending that money? I think it's a positive thing to have, even for myself. I think it's a positive thing to have. Did you use them to obtain financing? Because of the disclaimer clause, they were almost valueless. That's not my question. My question is whether you would actually use them to obtain financing. He's asking about appraisals that he got. Like, why did you get these appraisals if not to try and fool someone? I would give them, but I don't think anybody paid much attention to them because of the disclaimer clause and because generally that's not the way to do it. Again, I've been doing it for 50 years and they look at the property. I'm going to hand up to the witness a document marked as plaintiff's exhibit 1433. It's short, so you can look at it on the screen. This is a letter dated November 15, 2011. If you look down the bottom, it's your signature. Is that your signature, Mr. Trump? Yeah, it is. Okay, and who is Mr. Richard Byrne? He's an executive at Deutsche Bank. Do you know if he's in a commercial real estate group at Deutsche Bank? I don't know if he is now. I think he was then. Fair enough. I am asking, as of this letter, as of November of 2011, was Mr. Byrne in the commercial real estate group at Deutsche Bank? Yeah, it's 12 years ago. This is so crazy. So you sent this is the letter I sent, yes. And you're interested in whether or not they may finance the Doral transaction. Is that right? Right. You did not finance the transaction through the commercial real estate group at Deutsche Bank, did you? I did it through some other group, yes. Would that have been the private wealth management group at Deutsche Bank? Yes, very different people. Your Honor, I move 1433 into evidence. Statute of limitations, grant overruled. Granted, it's in 2-minute warning. We can stop here then. Okay, everybody. We'll take a break until 2:15. Have a good lunch. And I'll order the witness not to discuss this, blah, blah, blah. And that's the afternoon break. I'm on page 1541. I didn't get a chance to go through my thoughts about this decision. They brought a motion for a mistrial. The basis of the mistrial is involving Allison Greenfield, the clerk of the court, and that she sits up there like a queen on the throne. They brought a motion for a mistrial, and they moved for an order to show cause. I really wanted to walk through this order to show cause and explain to you what is weird about this entire thing. It's very, very strange. There's a few things that's strange about this procedurally, which reflect a certain level of the judge acted unusually here in the way he handled this. And this is something that really only a New York attorney would understand. There's two primary ways that you can bring a motion in New York. The first is by notice of motion. The second is via order to show cause. Notice of motion, you basically is usually a lengthier time period. This I'm going to explain to you. It'll take me 15 minutes and I'll wrap this thing up here. But I want you to pay close attention to this because this is something you're unlikely to find anywhere else on the internet, what I'm about to tell you now. Okay? So I want to explain to you procedurally the way things work in New York and why this was very unusual in a way that seems to reflect the very bias that Trump is complaining about. When you bring a motion, normal way to do it is one of two ways. You go by notice of motion or you go by order to show cause. Sometimes the court will direct you how they want you to file your motion. A third way is by letter motion, which is basically, it's a much less formal way where you basically file a request for relief in a letter to the court, and that letter is responded to by your adversary. But the idea to a motion is that your adversary, the non-moving party, should have a proper opportunity to respond to you. When you go by notice of motion, so you have to give, I think, 12 days notice and say, in 12 days, I'm coming forward to the court and I'm going to be asking for relief X, Y, Z, whatever relief you're seeking. If you want to have an opportunity to reply to them, you have to tack on an additional 7 days, and then they have to put in the response like a minimum, I think 19 days, and then they have to come back, and most attorneys do 30 days out on a notice of motion. And then they have to put in their opposition 7 days before the return date, or 2 days before. I'm drawing a blank right now. And then Rule 2214B of the CPLR, and you have to get you have an opportunity to reply. That's one way of doing it. The other way is via order to show cause. What is an order to show cause? An order to show cause is very similar. Whenever you, in addition to the notice of motion, you attach to it an affidavit and or an affirmation, and sometimes a memorandum of law. The affirmation, an affidavit is signed off by a witness, somebody who's an actual, usually a party or a representative of a party if the party is a corporation. So you attach an affidavit, and that's a statement of fact sworn to by someone under oath, penalties of perjury. And they are swearing to the relevant facts. Frequently, attorneys will also attach an affirmation. That comes from the attorney themselves. He or she will write an affirmation, which will basically sort of frequently parse together the facts that are laid out and sworn to in the affidavit by the client, and the legal arguments that you're sort of putting in there, which are spelling out why it is that you're seeking the relief that you're seeking. And you use the facts, you weave the facts from the affidavit into your affirmation to sort of present a little bit of a legal argument. You attach onto it a notice of motion, and you file it. The affidavit will frequently have exhibits attached to it. Your exhibits are evidence, documents that support the claims that are in there, things of that nature. A contract, a statement of admission, something like that. Any documents you have that are beneficial to your case, you would attach that as exhibits to the affidavit. Now, if you move via order to show cause, it's a much faster timetable. And the way things work is this. Usually you'll do it with an affirmation of exigency. There'll be a second affirmation, which basically says, this is a real emergency. We got to move really fast here. You can apply for a TRO, temporary restraining order, or other forms of relief. In this case, that's not really relevant because that's not what came up over here. You can move via order to show cause. And in order to show cause, what you do is this. You attach an order, a proposed order, that you want the judge to sign. When the judge signs that order, it's not granting the relief you're seeking. That's not the way it works. The order they are signing, the proposed order, is you put in your affirmation, your affidavits, your exhibits, all that other stuff that you lay out in the notice of motion. But when you attach an order to show cause, instead of it saying a notice of motion, which says, please take notice that I'm going to be moving the court on date X in 3 weeks, in a month, that will appear before this court in this room, in this location, at this time to seek this relief. Instead, you're coming to the judge and you're saying, you fill in the time. You put it down, what time we're supposed to come back here. And you'll fill out with blank spaces in there. In the form, I can actually show you the form of, like, let's say a classic order to show cause here, because I've done so many of these orders to show cause. So I can show you what a standard order to show cause format looks like. Or, you know what? Better than that. I'm going to just pull up what was actually filed in this case, because I can do that. I might need to re-enter in here. I can pull up the actual proposed order. Here we go. When we come to file documents in the state of New York, this is what it looks like. So this is the case number for this case. And literally all the documents in this case are listed here. And you have your 75 here per thing. 75, you want to know how many documents have been filed in this case? This is 75 documents. This is 75 different things that were filed here. This is page 1. There's page 2, 3, 4, 5. Let's go. How many pages are there? There's more than 5. Oh. Yeah. 1,600 filings in this case. Page 22. Now, this is what they filed. An order to show cause proposed. What's that? So, see how these little blank spaces here? Little blank space here? This is an order that they were hoping that they would sign. Whoops. Well, you basically say, upon reading and filing the next affirmation of Clifford Robert, dated November 15th, that's the attorney. The affirmation comes from the attorney. And the affirmation of David Demarest. This was an expert that they attached, David Demarest, who is a former judge. dated November 14, 2023. And exhibits, let the plaintiff, meaning we are the movement, and we're telling you, the opposing side, let that person, the plaintiff of the state of New York, by Letitia James, Attorney General, come forward before you have to leave this where they're supposed to come forward. This would be filled in by the judge. Part. That's like each court has it's considered its own separate part. So there's part 26, part 47, and they'll be in room XYZ. But every court is designated as that a certain part number. So in this part, IAS part, room whatever, the Supreme Court of the state of New York, you always put down the address of where it is, and then you put down a date. You can leave the date blank here. In notice of motion, you would fill in these dates. In order to show cause, you're basically saying, I don't know when the judge wants to come in here, but it's going to be soon. It's going to be much faster than a normal notice of motion time. And I want the judge to sign off and say that he normally would put in here on the 21st day of November 2023 at 9:30 a.m. or as soon thereafter as counsel may be heard. And this is standard language that this part over here, you would change. This is a form that we all have in our word. Anyone who's a litigator, you know, who's done any kind of work at all, you have this form set up where you basically would change. You have your caption here, and upon these, what documents are being attached. Over here, you're basically saying this is what's attached to support the motion, and over here you're saying and over here you put in this my adversary, and then you have this part here is the location of the court. If it's a different courthouse, you put down a different address, and this over here is filled in by the judge or the judge's clerk. And you say, oh, so he's like, oh, okay, I want them to come in here on the 23rd day of November, whatever day they pick, of November 23 at whatever o'clock in the morning or as soon thereafter as counsel may be heard. Why an order should not be made. And now you're spelling out what relief you're asking for in your motion. So you're saying the relief we're asking for. So it's your job, Letitia James, to come in on the date that he's going to fill in over here in these blank spots and explain why our application should not be granted. And our application is that we should be granted a mistrial pursuant to CPLR 4402 or grant such other and further relief as this court deems just, proper, and sufficient cause therefore appearing. So this such other further relief is standard language that we all will put in because that gives the court flexibility to basically do whatever they feel is appropriate that hopefully will be beneficial to you. So this is also standard language that they have here in B. Sometimes you'll have multiple things. You can be asking for 12 different forms of relief. As it happens, all they're really asking for is the mistrial. So but if there was 5 different forms of relief, it would be listed A, B, C, D, E, and then F would be granting such other further relief. This is standard. This is how we create these documents. Then after that, you say ordered. Now, when you're saying ordered, this is ultimately our objective is it should be signed by a judge. It should be that a judge should sign this thing. Ordered that opposition papers, if any, are to be served on defendant's counsel via filing on or before. Now, what is this? What they're saying here is they were expecting the judge would fill in here saying, oh, okay, so if you're going to come in here, I want you to have the return date for this motion that everyone's going to come in here and argue this before me will be on November 23rd. So the non-movement who's opposing it should come in here, should file papers 2 days before. So they would fill in this. The judge would handwrite. And this is all, when I say fill in, I mean literally they'll handwrite it. On the 21st day of November 2023, it is further ordered that reply papers, if any, are to be served, which they normally would cross this out. They almost never going to give you a chance for that. And the judge will frequently redline, just like these 2 lines of the order out, saying, I'm not giving you time to reply. Because we're working on a fast track here. There's no time for you to reply. So, and then they also tell you how you're supposed to serve these papers. Sometimes e-filing is good enough. Sometimes they want you to hand serve it. But in order to give this motion, what steps do I, as the movement, have to do in order to properly serve that my adversary has notice in time that they'll get their opposition in? So they'll tell you what your date is when you have to get this in. Services copies order, which is based, must be made by X date, by e-filing same shall be deemed. Now, sometimes they'll put in more than e-filing. Sometimes they'll say, they'll cross out e-filing saying by overnight delivery. This is the judge has carte blanche to write whatever he or she wants in setting up this list of different orders. But you notice there's no order here granting relief. All of this is just a set of orders from the judge as to when papers are going to be served, when the return date of the motion is, when papers are going to be served, how they're going to be served, when replies would come in. That's all they're signing off on. If there was a TRO, there would be more in here. If there was a request that right now I need relief immediately this second, there would be other lines that would be put in ordered here. But that's not relevant in this motion, which is why we don't see it here. And then normally here they sort of left out here that under here they would have signed Judge Engoran. Normally there should be like a little signatory section here, and that's basically how this order show cause is structured. And then and then they stamp it and enter with the clerk of court, and once it's entered with the clerk of the court, boom, this now becomes an order. And it's basically an order telling you how you serve your motion and when we're going to come in here for the motion. It's not hard for a judge to sign off on this motion because the judge is not giving you what you want when he signs this order. He's not giving anything that you want. He's just agreeing I'm going to listen to your motion at that time. That's all he's doing. If he signs this order to show cause, this is proposed. If he signs the order to show cause, all he is doing is saying, I will listen to your motion. That's all he's doing. And then, in this case, we can be fully confident that he'd sign this order saying, yeah, okay, I'm going to listen to your motion, and then I'm going to tell you to go jump in a lake after I listen to it some date in the future. But that is not what the judge did here. No. What the judge basically said is, I'm not signing this order. I'm not even really listening to it. I don't want you coming in here and arguing. I don't want there to be any papers. I don't want there to be any evidence against you or in favor of you, whatever. I am flat out rejecting your motion and not even going to entertain. Don't need to hear from the other side. Boom, you lose on your motion for mistrial. This is very unusual because there's no real harm in having this come forward, other than the fact that we know he's terrified about this becoming like more public fodder. But there's really no harm here in saying, okay, so come in here for your motion. And at that point, I'll reject your motion. No, he was because he doesn't want to have oral arguments. But he didn't even make the other side put in papers. Letitia James never had to put in any papers. The Attorney General put in no papers, and he's like, you lose. You lose, goodbye. That's weird. It's very weird. And it's particularly weird when you look at what he wrote. And this is the parts that are weird to me. Not that. Is this it? Let me see it here. Let's remember in the law in support of the motion. This is it. So instead, he signs an order declining to sign the proposed order to show cause. And what he says is this court declines to sign defendant's proposed order to show cause, seeking permission to move, not seeking to actually get a mistrial, but seeking permission to move for a mistrial when we're knocking that out. CPLR 44.2 says that anytime during trial, court motion may order continues to new trial, blah, blah, blah. Defendants supporting papers arguing mistrial is necessary because the court has exhibited bias, one, directly, as I publish a high school alumni newsletter with links to articles referencing this case, which is weird. It's weird as hell. And two, indirectly through my principal law clerk, Allison Greenfield, who may allege has violated 22 NYCRR by exceeding permissible amounts of political donations on a calendar year. There's actually more than that. They also say that they're sitting next to you as your clerk the entire time, which is bizarre. That's a third thing, that you're acting completely inappropriately in the way you're consulting with her, which that alone, if she was not biased, is something that's bizarre and is reflective of the fact that we're supposed to be judged by one person, not two. He doesn't really address that when he rejects this, which is a little bit of a problem here, but because they're going to be appealing this. They knew he was going to reject it, so they were going to be appealing it. And the way he rejects it does not do him service. He would do justice if he actually would have let them argue, because he opens up that much more a position of looking biased, as I'm about to explain. As an initial matter, to the extent the defendant's arguments rely on alleged facts based on editorial opinions that denounce plaintiff's case, such opinions are irrelevant and no evidentiary value. So I'm already knocking out most of what you said there, which to me I take as being opinion. Equally relevant is the expert affirmation yet another retired judge, David Damarist, who states that he was retained as an expert by defendant's counsel to opine on the legal basis for a mistrial. As I explained in my September 26, 2023 decision, order granting partial summary judgment, legal arguments are for counsel to make and for judges to decide. Therefore, such expert affidavit is neither necessary nor permitted. So what he's basically saying is you had a former judge put in a legal opinion, and that is not permitted. Because that's not, you can't have an expert, there's no such thing as expert testimony about what the law is. That's not part of the way things are structured here. I didn't look at Judge Demarest's affirmation. This is the affirmation of Judge Demarest. He's calling it, he's dismissing, this is funny. He's dismissing it as legal arguments. It's not legal arguments. That's the thing. Judge Demarest isn't opining on legal arguments. He's opining on proper conduct for a judge. If you look at what Judge Demarest, the papers he submitted here, I've been asked for my opinion with respect to judicial conduct. The judicial conduct is not how you're handling your decisions on the law. It's how you're conducting yourself as a judge. So when Judge Engoran says this expert affirmation of another retired judge is not to upon a legal basis for a mistrial, it's opining as it's an expert opining as to what's proper conduct for a judge. That's not legal basis. Therefore, such expert affidavit is neither necessary nor permitted. The rule permitting experts for providing the legal opinions or conclusions is so well established that this is ridiculous. This is such a ridiculous read by the judge. If he came in here and said the law is, if Judge Demarest wrote an affirmation saying the law is that you have to give a mistrial, that is in the event that somebody signs off, or somebody gives too much money to the Democratic Party. That's expressing a legal opinion. But if he expresses an opinion saying this is what's proper conduct and this is outside the norm for proper conduct, that is not a legal finding. That is an expert weighing in as to the way courts are supposed to handle themselves. But he's whitewashing past that, which I don't think he's going to necessarily succeed in that. I think that's a real problem. Like legally, his argument here is kind of bizarre. This court has already cautioned defense counsel against submitting expert opinions on purely legal. It's not an expert on a purely legal issue. Moreover, as detailed herein, former Judge Demarest's expert opinion incorrectly summarizes the relevant law and fails to address all applicable governing ethical guidelines. Now, this next paragraph is what Judge Engoran goes whoosh. Defendants correctly assert. Now he's going to address the whole Allison Greenfield with his whole girlfriend issues. Correctly assert that 22 NYCRR 100.5 generally limits to $500 the political contributions that members of a judge's staff may make annually. That was part of their basis. They're like, she's contributing too much money. She's not allowed to contribute that. However, defendants and their legal experts failed to cite the applicable unambiguous ethical guidelines for candidates for judicial office. So she's not just a clerk of my court. She's also a candidate for judicial office. Found in Judicial Ethics Opinion 898-19. Since 2020, my principal law clerk has been pursuing elected judicial office as the governing ethical guidelines for New York State law clerk expressly contemplate and permit. Indeed, Judicial Ethics Opinion 98-19 clearly states the $500 limitation on political contributions does not apply to an appointee's contributions to his or her own campaign, nor would there be such a monetary restriction on the purchasing of tickets to political functions. This paragraph is wacky. Wacky. Why do I call this wacky? Why do I call this wacky? Bizarro. Bizarre. Unbelievable. This is astonishing to me. This paragraph right here. Oh my God. What he says here is this. In this paragraph, he says, you're complaining that she's spending too much money. She's only allowed to donate $500 under the rules. Rule 22, New York Court Rules and Regulations 100.5, subsection C2 limits to $500. But you're missing something important here. There's an exception if she's running for office, and she's running for office. So you're wrong. You're wrong. Why do I say this is bizarre? Why do I say this is unbelievable? The reason this is unbelievable, the reason this is astonishing, the reason this is crazy is because remember I explained to you how an order to show cause would be at the motion stage, and he said, I'm not giving you a chance to have a motion. And I walked you through all the processes and procedures we have here. And I mentioned to you that when you have an affidavit, you attach your exhibits to support your position. He is saying he is coming to a legal conclusion. He is making a finding that Allison Greenfield, his clerk, is running for office. He's reaching a conclusion that the reason that she gave this money in excess of what she should normally be allowed to give is because she's running. So now she has an exception, and that's why she gave the money. How do you know this? I mean, we all know the way you know this is because you actually talked to her and she told you this. But that's not how things work here. That has to be attached in an affidavit from her. You have to establish a record for the court. There's got to be something on the record which explains how you know this to be true. There has to be an affidavit that's filed. Right now, on the entire record that's before this court, the public record that's before this court, all we have on the public record before this court is the fact that she has given too much money. Now, if there's a justification, if there's an explanation for that, if there's evidence to support that justification, and that gets presented on the record in the form of an affidavit, in the form of exhibits, in the form of something proving that she's actually running for these things, that is how you form a record that then could be reviewed by an appellate court. But there is no record. There's no affidavit. There's no evidence. Nothing has been submitted. I showed you how I pulled open this document over here where you can get a list of all the documents that came up here. There's nothing that was filed by the Attorney General. These are the most recent documents that were filed. The most recent one is his decision that was filed on November 20th. But there's nothing here that was filed. There's a letter correspondence to the judge. This letter correspondence is from the AG saying, hey, we really need more time to whatchamacallit. This is the correspondence from the judge basically saying we think that their motion stinks. Decision or motion, this is him saying this is just a formatting thing for the court. But all you have here is the proposed order to show cause that was filed together with a memo of law and the affirmation from former Judge David Demarest, and an affidavit from the attorney and the exhibits. And the only thing, but there's nothing here on the record which explains how the court knows that she's running and that that's why she gave these monies. Which means that basically what the judge is admitting in this order, what's so astonishing about this is he's accused of acting inappropriately and too congenially with his clerk. So he issues a decision saying, I'm not listening to your motion and you're wrong because my clerk told me in private that she's running for this thing and that creates an exception for her. If that's true, let the AG submit an affidavit from Greenfield explaining why it is that that's appropriate. Let Greenfield submit an affidavit. Let somebody submit an affidavit. Something that could be refuted, something that could be inspected. How do we know the judge is right about any of this? Well, the judge decides, what are you kidding me? Without there being any evidence on the record, there's zero evidence on the record that anything he wrote in this paragraph here is accurate. Zero, nothing at all. There's nothing. He just totally either made this up, which I don't think he did, or he had a private conversation with her off the record to say, give me an excuse as to why it is that you gave this money. And the excuse may, in fact, be legally proper, but the way he's approaching it is reflecting how crazy he is in the way he runs his court. Because everything here should be done formally on the record. This is a case that is of national importance. Everyone in the world is following this case, and you don't even have her submit an affidavit with some sort of exhibits to attach to it, which is actually explain that she really is running for office, and that's what these donations are for. When the very charge is you're so biased because you're working like she's your girlfriend instead of a clerk of the court. So how do you reject this motion? By basically having a private conversation with her with everything off the record behind closed doors. That's how you know everything here is really, really integrity. You know how? Because I had a private conversation with her off the record behind closed doors where she told me that she's running for office. Now, he probably knew it beforehand, but still you establish a public record so that this way the first department in the appellate, which is the appellate division, the first department of New York, would actually have a record to look at and say, oh, yeah, this is true. She is running. Here's the evidence. Here's the affidavit from her saying that she's doing it, that she's been running since 2020. And here's the evidence here that she, whatever documentation she has to establish that. How does anyone know that this is true? No one's sworn to it. How is anyone supposed to believe that this clerk that this clerk really is running for anything? Why do I think it's true? This is what the judge is claiming. Is the judge swearing to it? Has anybody sworn to this? No, nobody's sworn to it. That's the whole point to having an affidavit. You have something there that someone is committing perjury if this is not true. Who's committing perjury if this entire thing is made up? Nobody. It's just a representation from the court. How do you not have an official record which establishes what the basis of your evidence is that's in rejecting this motion? It is astonishing. It is mind-blowing. It's crazy. It's really crazy. Then he goes to all this thing with ducking the price of tickets and all this other stuff, and I don't even care to read the rest of his crap. Talks about his stupid alumni record. I read that part. I don't even want to go through the rest of this right now. Maybe I'll go through the rest of it tomorrow. But I saw that, and I was like, no one else is talking about this. So I, as a New York attorney, have to explain to you how crazy this is. And it's crazy. It's really, really crazy. It's really crazy. It's disturbing. It's very disturbing. I've been streaming for 4 hours and 20 minutes, though. I'm going to try and see. I might do on locals. I'm not sure where I'm going to do it. I'm going to see if I can try and finish up the rest of this transcript because I think people need to see it. I think people need to have an opportunity to see it. So I'm going to do that. I urge you to please like and subscribe. Let me see how my subscribers numbers. How are my subscribers numbers over here? How are my subscriber numbers on Trump trial? Did I hit 2K? Did I hit 2K? I close 1.6. Okay. If you could please like and subscribe, I'd be most obliged. Seriously. Seriously. For the love of God. For the love of God. All right. I see 1630. Okay. Anyway, also on Rumble, if you can like and subscribe there too, that'd be nice too. Got 388. You guys really stuck it out with me. Wow. Good job, you guys. Good job, Rumblers. Good job. It was a good rant. It was a good basis of law here. I don't think you're going to find anywhere else. I'm probably going to clip that and throw that up in my Trump trial. Throw that up there, a little clip. I'm wrapping up here. I'm tired. And I want to watch the second half of the Eagle Chiefs game. So I'm landing my plane pretty quickly here. Be happy. I'll see you tomorrow. Sign up locals. goodlodges.locals.com. Be happy. Eat some bugs. And as always, my friends, I say to you, Godspeed.